Yes.
Please, Your Lordship. Lordship, I beg to mention item number 6 of the list. Kindly adjourn the matter for 2 weeks. My senior, Mr. Gautam Chaudhary, is not feeling well today.
Okay, item 6.
Okay.
Adjourn of the prayer for made by Learned Counsel for the petitioner. My prayers for listing, give it to the court master.
Item number 27, madam. 27. Last time, madam, I was extensively heard, and considering that this requires some hearing, this matter was posted yesterday on hearing day. This is not sitting, madam, this comes today. May I pray, madam, can it be taken up some hearing day, so that it can be disposed of? On 7th, madam, it's
We'll try to have it in the last hours of the day. We'll just try to have it because the hearing days are already packed. Since I keep all those matters which I have had in part on the hearing days, I don't think tomorrow it will be possible to take up.
tomorrow, 7th of December.
7th of December.
I think.
Okay. 7th December. Joint prayer made by Learned Counsel for the parties.
My friend is waiting for the response.
Huh. Eight. Okay, after 2 weeks. Okay, after 2 weeks, I prayed for Learned Counsel of the petitioner.
Item number 7 of the hearing day.
7.
Yes, sir. Some health related issues for my senior, then they appeal, my lord.
Okay. After 2 weeks. Okay, after 2 weeks, I prayed for by counsel to the petitioner. Yes.
Chief, I'd like to mention item number 47. Item number 47. Your Lordship, the counsel for the respondent is not well today. If the matter could be adjourned.
You're taking consent of the other side?
Yes.
Okay. Both sides are represented. On the prayer made by counsel for respondent number 1 and 2, matter stands adjourned today. Interim order is there?
Yes.
Interim order passed earlier, stands extended till the next day of listing.
Next week, any dates?
I'm not giving a fixed date. Yes, item 1. What is the reason? What is the reason?
The reason is that my lord, the petitioner, my lord, she has no source of income, my lord. And the husband, my lord, after compelling her to leave the matrimonial house, my lord, has not paid any single penny, my lord. My lord will kindly see page number, my lord.
Penny can't be paid. It's a foreign currency. In India, you can't pay in pennies.
My lord will kindly see page
You
number.
have to pay either in money, either in rupees or in paisa.
Yes.
Pennies you can't pay.
Yes.
So what is wrong in that?
In Indian currency also.
Okay, Indian currency did not pay. Okay. Transfer petition.
Kindly see page number 20.
Transfer petition. Mr. S. Nawaz, S. Das, I'm sorry, S. Das, counsel for the petitioner. Matrimonial proceeding transfer from which court to which court?
My lord, from the target court of district judge Soraido, my lord.
District Judge Soraidev to
My lord, district judge Nogao.
District Judge Nogao. Matrimonial dispute, page 1, TSN 22 or 2023. Okay, notice steps within 2 days. Until the next date of listing, the further proceedings of so and so shall remain stayed, subject to condition that the petitioner shall produce a certified copy of the order before the learned trial court to bring the order to the notice of the said learned court.
Highly obey.
List 4 weeks. Give a fixed date in a matrimonial matter. Fixed date after 4 weeks. Yes, item 2. What is the reason?
Procedural reason is that the husband of respondent lordship. And respondent earlier instituted the lordship for degree of lordship nullity. in the principal as family court also. Thereafter, Lordship, she filed a withdrawal petition. During pendency of the petition, she filed a petition seeking divorce Lordship at Julhan Lordship. Only to harass the Lordship, petitioner Lordship. Thereafter,
Where is she residing?
is at present, as per her, she is residing in Julhan Lordship.
No, then we won't transfer.
She is the permanent resident of Guwahati. Guwahati Lordship. Lordship, I can see the marriage certificate.
No, marriage certificate will be, we don't know, because you see, marriage certificate is not a age or a address proof.
But Lordship, in the earlier suit, she has mentioned her address as in Guwahati Lordship.
No, maybe if if her matrimonial home is there, we won't stay it. We're just issuing notice, no stay.
Lordship, that during the pendency of the earlier suit, Lordship, she has filed this suit, Lordship.
Maybe there are compelling reasons we don't know. Not, no stay without hearing other side. Mr. N. Hassan, counsel to the petitioner. Application for under section 24 for transfer of matrimonial proceedings being so and so from so and so Jorat to Guwahati. Issue notice including notice on the prayer for interim relief returnable on so and so. Steps in 2 days. Where is the statement that you are paying our maintenance?
No.
No maintenance. Then you deposit 15,000 and cost to the registry as a condition for issuance of notice.
She is not seeking any maintenance, Lordship. She is not seeking any maintenance.
That's otherwise. But if you are not paying any maintenance to allow her to come to court, minimum 15,000 would be a reasonable fees for a counsel.
She is not seeking any maintenance, nor she has filed any petition, Lordship. And she is also, Lordship, qualified, Lordship.
I don't know. You see, my source of knowledge is abstract reading from the newspaper from here and there. I've seen in US the divorce proceeding lead to a financial settlement in thousands of dollars, sorry, millions of dollars. So even people who are well-to-do, they would be entitled to some cost. Notice subject to deposit or pre-deposit of 15,000 as cost of litigation for the respondent.
The amount may be considered, Lordship. 15,000.
I don't know. You just come after 5 minutes. You speak to your friend lawyers here who will be willing to appear in a matter of in less than that amount. I would record their name and that's end of it. I'm not asking you to disclose how much do you charge. But I'll give you 10 minutes time. You can move around with your friends, discuss. If 15,000 is unreasonable, we'll use it. But I'll get it recorded that in the bar, nobody would charge more than 15,000. Whatever fees your friends say, somebody will be willing to appear at 1,000 rupees just because of you. You are very good at the bar. So they may appear at 1,000 for you. But then I would pass a judicial order that no appearance more than 1,000. 15,000 is reasonable.
Okay, all right.
3.
Number 3 and 4 may kindly be passed over for the time being instead of.
Timing. Okay.
Okay, 5. Wait, this over. It's a very unfortunate case matter. Where at the fag end of the trial, when the case was fixed for cross-examination of EW's matter, the plaintiff filed a petition matter for withdrawing the liberty to file a fresh suit, and the learned court below, without giving any opportunity matter, straight away allowed the petition matter. Now, do you kindly see?
Where is the copy of that petition?
Yes. The
Withdrawal
matter
petition, where is that?
32.
32.
32. My lord will see the subject matter, petition under order 23 rule 13, read with section 151, praying for permission to withdraw the suit with a liberty to bring a comprehensive suit, my lord. Now, my lord, the practice before the lower court is that, my lord.
Yes, just now.
Yes.
Where is the plaint of the earlier suit?
Yes. My lord, the plaintiff is at, my lord, page number 14, my lord.
And where is that order? Impugn order?
Yes. At, my lord, page number 37, my lord. And on the same day, my lord, after registering the case, my lord, the order was passed on 31/8/23. First, my lord, it was written that both sides are duly represented, my lord, but we are not represented, my lord. We have not even submitted any hazira. Then, my lord, will see the entire order is a straightaway reproduction of the petition, my lord. And my lord will kindly see the last portion. Hard Peru's petition is allowed for ends of justice. The suit of the plaintiff is disposed upon withdrawal, my lord. No discussion whether there are any formal defects or not, my lord. What are the sufficient reasons, my lord? Whether it will cause prejudice to the defendants, my lord. No discussion, my lord. Straight away on the very first day, my lord, the petition was allowed. And if the defendants were really present, my lord, where are their objections, my lord? Nothing has been recorded.
Mr. S. Das, counsel for the petitioner, by filing this application under section
115 CP.
no, it can't be 115. Your petition would amount to restoration of the petition, the suit to file. It can't be under 115. You have it corrected. Just say the on the prayer made by learned counsel for the petitioner is permitted to correct the cost title. Is for a provision of law under which this application is filed. Full stop. The same may be done in the concerns civil division section. What is that? What is the civil division? CRP section is, what is it called? Civil division, the civil division, oblique concern section. And on correction, the matter would again be listed in the motion column. You do it today, it will come tomorrow.
Fine.
Because you see, 115,
Yes.
it has to dispose of the petition. In your case, it's not disposing it of.
I don't know. Item 9.
9.
Yes, must want to find an amendment agreement. That was rejected. Imperial order is page 49 and it's a 6. We have preferred another CRP before this court and the office was before this. Page 51 is the relevant portion.
You see, after his suit is dismissed, you file an application for amendment of plaint. How would that be?
A part of the suit.
No, but how is that possible in a appeal when the suit was dismissed?
Only one ground that agreement, that agreement was not signed by one of the co-sharers. So lordship, now the petitioner try to amend their claim saying that lordship, the share of that person who has not signed the agreement must be relinquished.
But is that type of amendment permissible in appeal?
Amendment of claim any stage lordship. And there is another provision. Also relinquishment of part of claim.
That is order 23, but it's applicable in suit. In an appeal to allow pleadings to be amended would amount to allowing a suit to be heard at the appellate stage on a point which was never there before the trial court.
So only I'm properly identifying my suit lordship. Earlier maybe it was a 10 bigger, now we are claiming 8 bigger.
Where is your amendment application?
Page 41. Here I have stated last line the lordship will conduct by reducing 1 kata 5 chaka 12 banda.
But Mrs. R. Chaudhary, counsel for the petitioner, agreed by the rejection of prayer for amendment of plaint by order dated 7/6/2023, passed by the learned district judge Hailakandi in TA 13 of 2017. The present application is filed under Article 227 of the Constitution of India. Issue notice, including notice on the prayer for interim relief returnable in 4 weeks. Petitioner shall take steps within 2 days for service of notice on the respondent by registered post with AD. Next para, as an interim measure until the next returnable date. The further proceedings of TA 13 of 2017 pending before the Court of Learned District Judge Hailakandi shall remain stayed. Ten. Yes. Mr. Bhattacharya.
Agreement.
What is the date since the matter was fixed for evidence?
69 madam, page 30 madam.
No, that you have started from one particular date. Where is the statement about the dates in which the case was ready for evidence? And your evidence commenced when?
21/7 madam. Accident madam.
Where do I find it?
Para 10 madam. Remember that my agreement is on the page 28 madam.
You produce this order sheet because you have, if you are not disclosing everything, you will not issue a notice. I can't help it. You see, you know that the relevant dates are when the case is fixed for what do you call evidence. What are the dates which have gone? So if you don't give us the entire thing, if you have the entire order sheet, you can show it to us right now. Because that's still this is incomplete. You see here it says that the date was fixed in 4/5/23. No, wait. No, you can't do anything. If I'm not satisfied, I'm not staying this suit. You see, if you in the orders there are mention about the earlier dates, and you are concealing it, it will. I would be happy to dismiss your application just for non-disclosure of material facts. Because the petitioner has not produced the order sheet on and from which the case was fixed for BWs, the learned counsel for the petitioner says whatever counsel for the petitioner is directed to produce all the relevant order sheet commencing from the date on which the suit was fixed for plaintiff's evidence. You do it whenever you want. Give us a date, we'll fix it on that day.
6, 7, 8, 7 madam.
No, not 7th, either 6th or 8th.
6 madam.
6th. Okay. Item 11. You give returning me this order sheet.
Right.
Yes.
My lord, we have challenged the interim order that lordship may kindly see page 50. 50. Here in this case, my lord, we have filed a title suit before the learned court below, that is Concept Court at Gualpa. Subsequently, it was discovered that there are so many formal defects in the state title suit. Then we filed a petition for withdrawal of the suit with liberty to file a fresh suit after removing those defects. But the learned court below first order, that is page 50, operative portion of the order may kindly be seen, page 52, my lord. So, sorry, my lord, I am extremely sorry. I am submitting item 12.
Okay.
Actually, it is item 11.
Yes, yes,
Yes, lost. Further together.
yes.
That's an include order page 50, right?
50.
50. Here, my lord, in this case, we filed 3 petitions. Those 3 petitions, lordship may kindly see, page 44. Page 44.
You are plenty for defendant.
Here, plaintiff, right? Plaintiff, here petitioner. Kindly see
No,
page
you see in your plaint, there is no mention about the consideration you have paid.
page 30.
Sale consideration, did not find it. If it is there, please point out. What was the sale consideration of purchasing that land?
That is my land. My land was illegally by putting thumb impression in the sita of the mandal, that is in circle office. The private defendants converted it as their own land. They got namjari. And after that, they also.
Where is the entry of Chitta? Where is the Chitta entry?
Chitta entry, that was my prayer. That
No,
chitta-
you are asking for the original to be bought in. But where is the extract of that Chitta based on which you have made that prayer?
Yes. In my plane,
There must be a Chitta extract.
yes.
Then you will call for the original. If you have not introduced that document in the trial stage, record will not be called for.
The record is called for because
No.
at the first time, my lord, we were unknown about this.
No, that's okay. But you see, without pleading, you can't have an evidence. There must be some pleading, some document. You see, even a copy of that order Chitta entry would have been there in the record. Then you'll call for the original.
That was not annexed. That is also one of the mistakes, my lord. But here, my lord, we have mentioned clearly about the matter which we want to rectify. Can we see the 16 matter? The learned court said that we have no pleading regarding the Chitta matter and also for calling the same.
That is the impression I am also having.
Page 16.
16, yes.
Yes. That the humble plaintiff received the periodic Kiraji Patta of the Sudland on 5/5/16, and surprisingly, it is found that the name of defendant number 3 and 4 have been included along with plaintiff in the aforesaid PK Patta of Sudland regarding 1 katha 16.5 lesa land out of 3 kathas 13 lesas of land without any bona fide material basis. Here, without any legal basis. However, then lordship can receive para 12 that after receiving the PK Patta of the suit.
What is the date of that entry? It's not given.
That is not.
Chitta entry is not given. Okay.
But when I came to know that is in para 12. That after receiving the PK Patta of the suit land on 5/5/16 by the plaintiff applied for Jamabandi and Chitta to know the actual fact of entry of name of defendant number 3 and 4 in the record of right of the suit land, and the humble plaintiff received the certified copy of Jamabandi on 2/2/17 and certified copy of the Chitta was received on 11/4/17. The plaintiff came to know from Jamabandi and Chitta that the name of defendant number 3 and 4 has included entry in the record of right of suit land on the basis of a LS registered gift deed number so-and-so. Accordingly, the plaintiff applied for certified copy of registered gift deed number so-and-so dated 25/7/2005 in the sub-register office of Bhaipuri. And plaintiff got the certified copy of the registered sale deed on dated 25/7/5 on 24/4/2017, and from the certified copy of registered gift deed number so-and-so dated 25/7/2005, it comes to the knowledge of the plaintiff that registered gift deed number so-and-so dated so-and-so has been illegally executed by the defendant number 1 in favor of defendant number 3 and 4 in respect of the land of Schedule B, though in fact the defendant number 1 never had any bona fide right
title and bona fide possession over the suit land of the Schedule A in any way or manner, nor had any inheritable or transferable right over the suit land. Further, the defendant number one never had any authority to execute any gift deed in respect of the suit land of Schedule B in favor of the defendant number 3 and 4. So, my lord, case is this, my lord, that is my land. Now, they put the thumb impression of purportedly saying that as I have put my thumb impression in the cheater petition. On the basis of that, defendant number one got the land, and immediately after that, he sold the same land to defendant number 3 and 4, gifted the land. The question is the transfer to the defendant number one is illegal, how he can transfer the same land by way gift to defendant number 3 and 4. So, my lord, that was clearly mentioned in our petition, and our lordship may kindly also see page 18. Page 18, para 17. That the knowledge regarding illegal inclusion of name of defendant number 3 and 4 in the PK Patta came to the receiving the PK Patta of Suitland on 5/5/16, and knowledge regarding the registered sale deed number so and so dated 25/7/5 come to the plaintiff on 2/2/2017, and on 11/4/17 after receiving the Jamabandi and Chicha of the suit land, hence this suit is not barred by limitation. So, my lord, I think actually that was not the matter here. Chicha, it appears Chicha and Jamabandi are there only. Now, question is this: by way of putting thumb impression or signature in the Chicha of the record of right, the land cannot be transferred. That is not the law. That is normally used, but that is illegal. That is the first thing. Second thing is this: whether that thumb impression belongs to me or not. So we filed 3 petitions. We filed 3 petitions. Number one was that a circle officer may be called upon to adduce as witness. Number two, to bring the record of Chicha meditation from the office of the circle officer. Number 3, to send the same to the forensic science expert. Now, the learned court below accepted the plea that circle officer may be added as one of the witnesses. He may be called upon. But so far, Chicha meditation and calling of Chicha records and also sending the same to FSL expert, that has been denied.
Where is the order?
Yes, that must be kindly see, page 50. I am reading well, relevant question. The second, third paragraph. Right petition number 291419. The plaintiff has prayed for summoning the concerned circle officer as a witness for proving his case as the cross-examination of the official PWS.
No, you omit that part. So the second part.
Yes, that is allowed.
White petition number 2919.
Yes. 2918.
No,
That is-
2919.
2919, that is rejected. 2919,
19.
that is also rejected.
No, read that part.
Yes. Right petition number 291919, the plaintiff has prayed for sending the thumb impression contained in the relevant CITA or for expert opinion. The defendant said has side also raised objection against this petition filed by the plaintiff on the ground that the plaintiff has not challenged the thumb impression which appears in the relevant CITA, and as thus stated that prayer of the plaintiff to be not maintainable. I have considered submission of the learned counsel appearing for both the sides on the above mentioned petition. I have meticulously produced the record of the present suit.
So that is what the question is. You see, unless you introduce that part, how in an evidence something can be allowed to be brought in, which is not even a part of pleadings? You want to prove your thumb impression on the chitta. That they have disclosed that in the written statement, more specifically in this in para D at page 29. They have made a specific averment, but the plaint was not amended to challenge the thumb impression allowing the transfer in chitta. Now you are calling for the original chitta book to prove that the signature is not yours. That is why the signature, the thumb impression is also signature that you will find in Black's Law Dictionary. It says mark of a person. It does not say signature means handwritten signature.
Yes, that
So even a thumb impression is a signature.
that is
Now-
also exhibited that time.
Now that thumb impression, once it is not denied, how can you lead evidence to disprove that in the absence of pleadings?
The defendant may raise objection, but court will say, so far our plaintiff is concerned, we have made statements in para 10, para 13, para 17. Lordship has already heard. So there are indications that we came to know when we went to the circle office at Vayapuri. We found that our land is recorded in the name of defendant number 3 and 4. Then we came to know that defendant number 3 and 4 got the land on the basis of gift from defendant number 1. Now question is this: defendant number 1 has gifted the land to 3 and 4. How he can? Because by
I would not understand that. You see, reason is very simple. In your plaint, let us assume that you did, at the time of your plaint, you did not know about the thumb impression in the chitta.
Yeah.
Now, when the written statement is there, you come to know that in the chitta book, you gave a thumb impression permitting the transfer. At one point of time, these transfers were prevalent in the state of Assam all throughout.
yes,
Now, but in your plaint, either you have to amend your plaint and introduce something that the thumb impression was not yours, because only you can lead evidence only to prove what you have said. That is first. Second principle is that the defendant takes a plea that the thumb impression was yours. It is his onus to prove it. So because you see, without introducing pleadings with regard to the thumb impression, how can you be permitted to lead evidence to disprove that? You see, you have Evidence Act with you. See section 3, there's prove and disprove.
but evidence part, well, at this
No,
stage-
but how can you lead evidence? That is the question. Huh. Prove, not proved, and disproved.
But order 11, rule 14 and 16 says that anytime the plaintiff or defendant may file a petition calling for the record, that is there. That is
No,
only-
nobody is disputing that. Proposition of law, I am not disputing at all. But Evidence Act says what is to be proved, what is said to be not proved, and what is said to be disproved. So unless you you have pleadings, it will be very difficult for me to accept that you can lead evidence. Show me a single line that you have.
The pleadings is there.
No. You show me that pleading that you have disputed that thumb impression is yours.
Yes, I have said that. That
Please
is
show us that I am ready to read it again.
Lordship, may kindly see page 17. Actually, my lord, we cannot go beyond record.
No,
This is
you see, I am not.
clearly mentioned, but indications are there.
No, Mr.
And I think
Mr.
it
Mahmood,
should be valid.
I'm not saying anything against you. What I'm trying to understand is that principle, whether if I'm right, that no evidence can be led without evidence, without pleadings.
Yes, that is true. But
So then you'll have to take another course.
no, this is there, my lord. This is
I'm there
there.
at page 17.
Yes. Yes, page 17, Lordship may see.
Yeah, I've seen that.
From top,
Shows.
further, defendant number 1 never had any authority to execute any gift deed in respect of suit land of schedule B in favor of the defendant number 3 and 4, as such the execution of registered gift number so and so by the defendant number in favor of defendant number 3 and 4 is very much illegal, null and void in the said gift deserve no merit. Then Lordship would say after a few lines, and mere entry of the name of defendant number 3 and 4 in the record of right of the suit land does not create any title in favor of defendant number 3 and 4. Hence, the humble plaintiff challenge the LS registered gift deed number so and also challenge the mutation of the name of defendant number 3 and 4 on the basis of LS registered sale deed number so in the record of right. As such, the LS registered gift is liable to be cancelled, and name of defendant number 3 and 4 is liable to be deleted from the records of right of the suit land, and accordingly entire suit land measuring 3 kathas 13 lessons be recorded in the name of plaintiff. Now, Lordship, so far putting of signature, thumb impression, that is not so much clearly mentioned, but that is the formal defect, my lord. But I think court should be liberal a little, because drafting for the amendment is one of the way, but amendment.
No, I don't know, because I can advise what to do, what not to do, but I'm just on the principle of law. Can an evidence be led without pleadings?
No, that cannot be. Because,
So therefore, you'll have to take our call.
but that is. That family person clearly not mentioned. However, Lordship may kindly take up this, but at 2 p.m. Let me go through it a little thoroughly.
Okay.
At 2.
12.
Yes, 12, my lord. That was. Here is also, my lord, more or less same thing. Here the case is petition was filed to withdraw the case with liberty to file a fresh case. Now the learned court below has passed the improved order.
Where is your application for withdrawal?
Application for withdrawal that may be seen page 20, my lord.
20.
20. Where is it?
No.
20. Alexa 2.
You see, we're given no reasons.
The reason is there, my lord. The 3, para 3 may be said. That it is submitted that the suitment is a government first land and relief has been sought for right title to interest in the suit land on adverse possession. Whereas the state of Assam has been made as performer defendant. It is not only to maintain that many people mention that the relief has been sought for against the state of Assam, and so the state of Assam ought to have been made a party as principal defendant, and but it has been specified, and if any amendment is made in this regard, the subject matter of the title of the suit will be changed. Then in the interest of justice, the plaintiffs may be allowed to withdraw themselves from the suit with liberty to file the case on the same cause of action. So here is a case, my lord. Some plot of land, there are some defects. First thing, my lord,
You see, I'll tell you, so far as your plaint is concerned, it is at page 14. In 14, you have structured the plaint that the defendants are trying to dislodge you,
yes,
to dispossess you. And now you say that the land is a Tozi Bahira land, and therefore there is an adverse position. Now you see, the relief sought for the ground of paying for withdrawal has got no nexus with the plaint. You can withdraw it and then come in a suit. There is no issue. But here you see your introduction of any pleading with regard to adverse position against the government is not there.
Yeah.
So if the withdrawal is for a separate cause of action, then that withdrawal, what you call, can't be within the meaning of Order 23 Rule 1 with liberty to 1(3) to come again.
that
Here-
is my prayer. Because
But can
we have
that be granted?
to, my lord, first thing is the entire case is based on the adverse position.
No, no, no.
That is 30
No, you
years.
see, withdrawal is on the ground that there may be some formal defect.
Yes.
Non-pleading of what you call pleadings against the government is not a formal defect.
Yes, it is a defect of high magnitude, I understand that. But thing is this, that is why, my lord, that is why my prayer is this. The government is the main party because when we have claimed something on the right title or interest, on
No,
the
no, no.
basis of adverse possession,
No, no,
it is the government who will provide us, not the private.
no. You see, in your, that's why I'm showing you your plaint. In your plaint, there is no statement against the government. The pleadings are against the main defendants that they are trying to dispossess you. So therefore, even a person who has no title, if he is dispossessed, he can come to court and file a suit against dispossession. There's no issue with that. But to withdraw the suit and then come again with a prayer for adverse possession against the government, for that you are asking leave to withdraw to come again. You see, there are several issues which will crop up.
But on here, my lord, that what are formal defects? That definition is there. Formal defects, otherwise means that if those are not rectified, the purpose of filing the suit will be totally vitiated and prayer would be meaningless. Now, in this regard, the Honorable Supreme Court, in a judgment, Lordship may kindly, that is 2017, 172 AIC.
You have to give me a copy because today I don't have my
Yes,
tab.
my lord. 2017, 5 SCC 63. I am reading the relevant portion only. Here, Lordship may kindly see para. I will give it this time. There are 10. Kindly see. In case Bhupati and others versus Kukila and others 2005 SCC 458, it has been held that it is the duty of the court to be satisfied about the existence of formal defect or sufficient ground before granting permission to withdraw the suit, who is liberty to file a fresh suit under the same cause of action, though liberty may lie with the plaintiff in the suit to withdraw the suit at any time.
Can you file an affidavit saying that you will not introduce a cause of action which is not pleaded in para 15? Are you prepared to file an affidavit? That
may be done, but thing is this, my lord, formal defects are available. Even the
no, it's okay. Once you have read that part of the
land,
once you have read that part of the judgment, it must be based on the same cause of action. Now, are you prepared to file an affidavit that you will only restrict yourself to the cause of action pleaded in the plaint?
but some prayer portion should be
No,
remanded.
that's okay. If you are withdrawing it, you can do it. But if you can file an affidavit saying that you will restrain yourself to the cause of action pleaded, we will accept your statement.
But the prayer, my lord, there's a different.
So prayer, definitely when you are withdrawing a suit, you will have to file a different prayer. But before that,
a cause of action.
but before that,
remains
before you make that statement in the court, please read page 15.
of my claim, of my petition.
Yes.
Yes,
Your cause of action for the suit is 26/2012.
yes.
If that be so, then your cause of action for adverse possession will never be there. You still want to file an affidavit, do it.
Whether it is continuous. So
I don't know. I don't know. I take you see, I'm only reading what what you are showing me. What I read is what you get.
the case of 2013 and cause of action arranged in 2012.
No, that's okay.
So
If you file an affidavit, that's okay. You
the
file it
cause
by
of action, my lord, that shall remain same. That may.
you file an affidavit. You file an affidavit, bring it tomorrow. We'll take it up day after tomorrow.
That is on Friday. That is on Friday.
Friday, okay. In course of submissions, comma, by relying on the case of, just pass me that.
Yes. 2000. We are very much distressed for drafting.
It's okay. I am taking it your statement at face value. I'm not questioning your submission. Case of V. Rajendran, V. Full stop Rajan, RAJENDRAN versus Annasamy, ANNASAMY, Pandian, Pandian, within bracket D, to LRs, comma, 2017, 5 SCC 63, comma, it is submitted that the petitioners are seeking to withdraw the suit and to file again on the basis of same cause of action. Full stop. Next paragraph, if that be so, the petitioner is at liberty to
After correcting.
file an affidavit to the effect that the cause of action would be would be same as pleaded in TS 6 of 2013. Next paragraph, list on Friday.
All right.
Yes.
Then the appeal got, as many as 45 reference cases were not decided. But already around 20 of them have been admitted and fit for hearing. The lead case being LA appeal number.
Why this is come late? There was a delay condonation.
Yes, earlier.
Okay.
There was
Okay. Heard. Mr. R. Dubey. This is item 13. Heard Mr. R. Dubey, learned counsel for the appellant. This appeal under section 54 of the Land Acquisition Act, 1894. The costal you are not given. Which case?
That is, if you also would say serial number 3900. It's a reference case 200 of 2001.
39.
Yes. Number 39.
Where would I find that page 30, that serial 39?
Other ones can you find at page 18 matter.
Page 18. Again, judgment and order dated 30/5/2015, passed by the learned
Case number
district judge Kamrup.
case number 1.
Additional district judge number 1. Okay, additional district judge number 1, Kamrup Metro Guwahati, in reference case number
200 of 2001.
39. Okay, reference case number 200 of 2021. Sorry, 2001. It is admitted for hearing. Issue notice returnable in 4 weeks. The petitioner shall take steps within 2 days for service of notice on the respondent and the pro forma respondents. List after 4 weeks. Let the record LCR be called for. LCR, let the LCR be called for. After that, list after 4 weeks. Okay.
Item 14.
Just a moment.
Husband is
Mat-
released. I'm not challenging the entire part, my lord. I'm only challenging the, my lord, the permanent element of part, my lord.
That appears to be quite reasonable.
My lord, permanent alimony, they asked for 20 lakhs, my lord. It has been granted 15 lakhs. The lordship will find page 31. Page
You see in the internal page 3,
internal page 9, my lord.
no, internal page 3 of the order, the, with what is written there, I don't think that the amount of permanent alimony would be wrong.
Your lordship, kindly see the evidence part. my lord. Discussion. My
I don't
evidence, my lord, in fact, my lord, your lordship shall- that I have seen, my lord. It is not well established. My lord, it is not.
I don't know.
My lord, that is the
I don't
evidence,
read it
evidence is,
thoroughly.
my lord. Your lordship will find page
I just
31.
read here and there and then form an opinion.
Page 31, my lord. And it is a well established business as well, my lord.
Just a moment.
In fact, it's a Tata Magic driver his permanent income is Tata Magic. My lord. He is driving a Tata Magic. Apart from that, he use of this, my lord, contracts work in contract level. In the contract level, my lord, it's a pretty that mustn't. He has
Just,
some liabilities of his parents, my lord. He's the only son. That part is in the evidence, but that is not brought into record in the judgment. I've gone through the evidence. Evidence it is said that he is the only son having 4 parents. He has that liability.
okay, but you have to, as a precondition, you have to deposit 50% before the trial court.
My lord, first of all, my lord, my submission is that I'm taking the, my lord, the 8,000 per month. That is, I'm paying very much. My lord, I have no objection on that. Only at least is this, my lord, if your lordship can. let
No,
him
but some
ask-
amount you have to deposit. 50% is good enough.
My lord, if your lordship directs, my lord, then the petitioner to the appellant to file the, my lord, rights in liabilities and assets, then also your lordship. Probably that part was supposed to be taken by the district judge, but that was not taken consideration. And my lord, the district judge asked for the liability.
Assets and liability statement you did not, never introduced. So therefore, the evidence was accepted because of the fact that you have a vehicle and that you are and that you are not denied that you are doing contract with the panchayat.
I am not denying that I am doing small contracts in the, that part is there, man, but you cannot earn more than, my lord, 50,000. It's impossible to earn 50,000. Even in fact, my lord, can a magic driver? He drives a magic, sometimes he does that. That is the only two incomes. My lord. Can a magic driver can earn, provide 15 lakhs as a permanent eligibility?
It's not impossible,
Not possible, my lord.
not impossible.
Not impossible, but is it a reasonable, my lord? It's my submission is that it is not reasonable. Let him come, if my lord, let the notice go the time being, I'm paying that this part will be state, other I'm paying that. Other.
You have to deposit 50%. We may not permit her to withdraw it, but you'll have to deposit 50%.
That is not possible for his point of view. He is not that capable to deposit that much amount. my lord.
Question of capability is not an issue.
So that
If you are a hardworking man, you have to earn it and give it.
definitely, my lord. My submission is that at this stage, my lord, if your lordship finds it permanent after it, my lord, after going through the records, if your lordship finds yes, it's permissible.
No. You see, I'm sorry. You see, in the trial court, it was your onus to show that you don't have that earning capacity.
Yes, my lord, I have given my, in fact, in evidence, my lord, I have.
Okay, we'll take it up day after tomorrow. In one of the contract which you have submitted before the panchayat, show us in a period of 3 years, shows any three contracts of yours where your financial ability you have disclosed.
Let me get it, my lord, after, because it will take 2-3 days time, so let it
No,
come.
no, it can come, what you call, by WhatsApp, it can come by 2 o'clock.
That is true, but my lord,
Contractor will have all these documents ready.
possible, I'll try to get the, my lord, income tax, if we have it.
No, not income tax. You see, you are a contractor. You submit along with your tender, your financial capability. You show me a document where your financial bid in one contract.
That is there, my lord, definitely I will get it. Whether it is there or not, I have no information. If it is there, I will definitely submit, my lord. It will be beneficial for me, in fact. If it will be beneficial for me, my lord, definitely I will get it out.
No, you see,
No, I'm not saying, my lord, whether it is there or not, I don't know. Because whether he had submitted any, it is their allegation, my lord, their evidence that I'm a contractor. I'm not denying that I did not do contract, but I have to get whether any documents are available with him or not. So
Okay.
I'm not saying, my lord, that.
we'll take it up on Monday then.
Get it in next Friday. Next week, not in the Monday, but Friday.
Friday, okay. On the prayer made by Mr. J. Payang, counsel for the petitioner, based on 8/12/2023. Fifteen. Yes. Yes.
Matter actually relates to my development of apartment. Petitioner before your lordship, there's a builder who is engaging the business of my development apartment. In the present case, they have
Just a moment. Okay, yes.
in the present case, they have taken by the development agreements, land from different fathers. 10 began. Some of the fathers instituted suit, including the respondent. In the suit, my lord, is the title suit. If your lordship, it is the prayer that was made, my lord. There's a stick your lordship to page 35, my lord.
Page 35.
Was instituted by one of the landowner, my lord. Which is released, my lord. Page 35. Measures with me.
Yes.
Number one, declaration that the deed of agreement being deed number, that is the development agreement. In 19 to 2015, in the irrevocable general power of attorney being deed number so and so, dated 19 to 15, obtained by the defendants by plate for upon the plaintiff, the same are liable to be cancelled and delivered. Two, cancellation of the deed of agreement being deed number 1892 dated 19 to 15, and irrevocable general power of attorney being deed number so and so. The receipt may be issued to the senior sub-register Kamrup Metro Guwahati for recording the cancellation of the deed of agreement being deed number so and the general power of attorney. Then recovery of possession of the suit land and thus vacant possession of the suit land as described herein below by delivery of the plaintiff, removing all the main materials of the defendant. Permanent injunction restraining the defendants, their men, agents, workmen, and associates from doing any construction over the suit land and changing the necessary character of the suit land and also encumbering the suit land in any manner. After the recovery of possession of the suit land, the defendant men, agents, workmen, and associates may be restrained from disturbing the peaceful use and occupation of the suit land. Now, along with the claims, my lord, an application for injunction was also filed under order 39 Rule 1 and 2. Now, that part, the learned trial court, my lord,
If your lordship peruses page 69 to 75, relevant portion is page 73, my lord. Page 73 onward. my lord. From the last paragraph of page 73. This is the decision of the learned trial court on the injunction application. my lord. The relief of injunction is an equitable relief, and the court has to look into the established principles, namely prima facie case, irreparable loss, balance of convenience, and public interest before granting temporary injunction. In the instant case, the plaintiff has filed this case praying for cancellation of agreement and power of attorney along with other reliefs, as the defendants, after entering into the agreement to complete construction on the land within 36 months, failed to do so. It is evident from the record that the construction has not been completed as per the time mentioned in the agreement. As such, the plaintiff has a prima facie case in his favor. In the instant case, it is admitted that the present construction is going on the construction of G+2 has been underway. It is also evident that the defendants have entered into agreement with intending buyers of the flats to sell the flats in the residential complex constructed in the suit land. And many buyers have invested their money by way of taking loan, etc., expecting to possess the same within a specified period. Perusal of the affidavit shown by the plaintiff also reveals that the plaintiff is aware of the fact that the defendant has entered into agreement with intending buyers for sale of flats. In view of above fact, I find that if the construction is stopped at this time, the defendant and the intending buyers will suffer irreparable loss and the inconvenience rather than the plaintiff. Moreover, granting injunction to stop construction at this stage will cause irreparable loss to number of intending buyers and investors, and as such affect public interest at large. The suit land in this case was handed over for purpose of construction of flat, and stopping of the construction of same at this case will not provide any relief to the plaintiff, which cannot be otherwise received or which cannot be effectively granted at the time of disposal of the suit.
You have a photograph of the site, construction site. What is the present status of construction?
My instruction, construction can be stopped. What has happened, my lord?
No, what is you say? I just wanted to have an overview of the nature of construction. Mr. Roy, you have a copy of?
I have a sketch, my lord.
There was a inspection by the GMC and GMD lordship when the matter went to the RERA. They have reported, I have annexed that in my affidavit in opposition. Till that there is no construction is going.
Can you bring a copy of photograph and show it us at 2 o'clock? Land is at Guwahati.
In another matter, my lord, in RERA also passed some orders. We are on appeal against that also. my lord.
Builder has been imposed lordship a penalty
No,
of.
I'm not on that. Whatever they have done, I'm not on that. I'm just seeing the injunction application. I just wanted to see the site.
Lordship,
Can you-
Lordship, please to produce the affidavit in opposition.
Yes, which page?
Please, lordship. Page lordship 161, and except
161. No, because you see, this land is what I get from this schedule. The land is at Panvajar. Why can't somebody go and have a Gotanagar? Oh, that Don Bosco school is there also.
Lordship.
Don Bosco school is there also.
Yes.
Okay. Oh, okay. Institute. I saw somewhere Don Bosco school. That's why I'm asking. Land of Don Bosco. Oh, acha, that is Gotanagar. Okay. Okay. Yes, page. Which page?
Lordship. Yes, start from. Lordship, page 261.
261.
61. This is the inspection report. Lordship, the respondent lodged a complaint before the RERA authority that the developer, that is the petitioner, is not registered with the RERA authority as required under section 3 of the RERA Act. Then the RERA authority lordship lodged a inspection lordship along with the GMC and GMD expert engineers lordship. And the report was submitted lordship.
Yes, I'm there at 261.
Just page 161.
One,
It starts from page 161. Lordship, I directly come to page 164, where Lordship, over my land construction has been shown 0. This report is dated 7/4/23. Part of the
which is your land?
My land is Lordship.
ABCD, which one?
Name of the block Lordship is from EE.
B and D.
EEL. Mentioned.
Which is this plot? D, which is that plot? It is a respondent's plot.
PC, my block is, I have stated in para plotting, page 139.
Now just tell me which is it?
Yes.
Which is your plot?
My plot is block B and C.
B and C.
Yes, Lord.
But B and C,
160.
total slab constructed 1. Status of other construction 0. B and
My B and C.
C.
B and
C is 4th floor complete.
B Lordship will see on the right side, 0.
No, that is total number of slab constructed is 1. Total slab constructed 7. So therefore other works are 0.
No, Lordship, on the left side, your Lordship will.
I've seen that.
Block B.
No, I don't,
construction
Mr. Roy. I don't read one line when I'm reading something. You start from second. Total number of slab to be constructed is 8. The second is total number of slab constructed is 1. So if you say 0, you are misleading the court.
No. How I am.
No.
I am
You see, you are saying read 0. But why will I read 0 when there's something in 0 it is read? Status of other construction work is 0.
But
So
my
please,
plot is.
Mr. Roy, please don't confuse the court. I am already confused.
Lordship, I am not confusing why I should, I have. stated
But you
I-
see,
never will-
number of slab constructed is 1. Total slab of constructed is 7. So it is not 0. 0 is other construction.
Lordship, there are more than 20 numbers of the land plot.
No, I am not concerned. I am asking for you. You said B and C. So I have started reading B and C.
Yes.
So in B it is not 0.
It is Lordship, extreme right side, 0 has been got.
And in top of that, what is written, Mr. Roy?
Status of the
Please don't
construction-
provoke the court to give unnecessary comments.
No. Status of the other construction.
Other construction work. Then other construction is many things.
A is up to 5th floor, then B is 0 Lordship. And C is.
No, what is 0? 0 is other construction. Other construction, definitely, the walls will not be there. If the slabs are not completed, walls will not be there. Sanitary fittings will not be there. So other construction will be 0. But one slab is constructed. So when one slab is constructed, it is not 0.
Heading is a status of the other construction work.
Other construction is what you tell us.
So
I have told you what I have understood.
against B Lordship, it is shown 0.
I am sorry, Mr. Roy. It amounts to misleading the court. This is not appreciated. When the court respects the counsel, when I am hearing half of the time I don't open the file. And when you say 0, it is misleading the court because you see, number 2, number of slabs to be constructed is 8. Total number of slab constructed is 1. So that means foundation is complete. Slab number 1 is already casted. So only 7 floors are to be constructed. 7 more slabs are to be constructed. After that, other constructions will come, which is separation walls, outer walls of each flat. The outer constructions will come on later. That would not be a part of slab.
Lordship, I am pleased to come to the.
No, it's okay. I'll take Mr. Rao's statement first. I'll come to you. Yes.
Now the main demands of before your lordship in this present proceedings today, lordship, what has happened? After the injunction was refused, my lord, they preferred an appeal before the appellate court. Now, in that appeal, my lord, if your lordship, that memo with which we have annexed as annexer
The agreement of which date, Mr. Rahul?
15.
Agreement is of which year? 2015. We are in 23, 8 years.
Yes, certain explanations that we also have to give about this. Madam, it was that this land belonged to lot of Pantadas. The approach road was not available. We had to enter into negotiation with many third parties to first get the approach road so that we can get a permission from the GMB. Unless we get the permission from the GMB, it is meaningless, my lord. And it's such a big plot of land, my lord. Taking up sporadic construction, no builder will be able to do, my lord. Within portions, my lord. It has to be in one go, my lord.
No, Mr. Rahul, that can't be appreciated because you see, the principle of caveat emptor will be there. You enter into a land where there is no approach road, you have an agreement made. These people are waiting for 8 years. Now you can't say that I wanted land on the right, I want the land on the 4 boundary wall. Everywhere I want an exit, and therefore I did not get an exit. And therefore, you see, this is something you should have thought when you enter into an agreement.
I understand, but the nature of the project was already known to the landowners, my lord. Rather, what kind of project will come up here, my lord?
No, but 8 years waiting, somebody making wait someone for 8 years. After that, the injunction is justified.
That can be case for compensation, my lord. I understand, and they have given extension of time also. DOT they have given to us, my lord.
No.
My lord, that I can show from the
Complete your part.
It was for 36 months. After that, my lord, they have by not by implied consent, my lord, they have given us, my lord, we took, my lord, their consent, and then we move ahead, my lord. That is another plea that we take before the trial court, that whether the time will be essence of the conflict for it. But insofar as these proceedings are concerned, my lord, that before the appellate forum, they brought on record new facts which were not even available before the trial court. That is
Shows that.
Lordship, if your lordship peruses page 82 of my revision petition, my lord.
Yes.
This is a part of the memo of appeal which they have referred before the appellate court, my lord.
Yes.
At the interlocutory stage, my lord. Up to paragraph 19, these were from the part of the pleadings. Thereafter, my lord, from paragraph 20 onwards, my lord, these are new pleadings which they have got on record, my lord. And the pleading was also not amended. The injunction applications, the bundle of facts which were available before the trial court to reject the injunction were totally different, my lord. That is the plea I am trying to raise before your lordship today.
Who is Narayan Chandra De?
And then the brother-in-law of the respondent.
Brother-in-law of the respondent.
The builder caused forgery of the sale deed. Charge sheet has been submitted against the builder.
Pardon me?
Will by forging a sale deed of the Lordship Narayan Chandra Das, the builder got land transfer in their and obtained the GMD permission in their name, claiming themselves as the owner.
I'll come to you, Mr. Roy. Let him complete. Otherwise, I won't be able to.
Your Lordship asked.
Yes, complete that.
So these facts were never before the mind of, that is my limited campus with which I am before your lordship. Then had these facts, had these pleadings been before the trial court, then I would have given a proper reply to this. These are new facts brought in at the interlocutory stage.
Where is the impugn order? Which page?
Impugn order starts from page 124, my lord. My lord, 106, there are two orders, my lord. First 106 by which that my lord, the refusal to grant injunction was set aside and subsequently injunction was granted. So there are two orders which we have given, my lord. 108, if your lordship peruses, then from my lord, page 109, the ground which the appellate court has narrated, my lord. In page 109, if I may take your lordship.
Yes.
My lord, from paragraph 6 onwards of the judgment, my lord, the grounds which were averred, my lord, these are new facts, my lord, that was brought on records. The grounds are supported by new facts. Claim has not been amended even immediately.
Mr. Rahul, I'll not be interfering with the interim injunction. The reason is that despite what you are saying, which appears to be right, they are introducing a third party pleading in the appeal. But the fact remains that if the petitioner is seeking, the respondent is seeking cancellation of the agreement and reversion of the land back to them, the prima facie case is in favor of injunction.
Yeah, my lord,
Irrespective of the fact that some new pleadings have been introduced.
a few moments ago, a query has fallen from the lordship that what is the stage of construction? Now that will also have a hearing. Just my learned team got a photograph from you. Can I show you?
That's
I got a lot of prejudice will be caused, my lord. Now the construction is not allowed. And the demands which have been expressed that there was some mischief done, my lord, without going into the merits of that, those have been rectified, my lord. Those have been rectified. My instruction, everything has been corrected, my lord. There is no that cause of action no more remains.
no, but you see, for 8 years, if some people are waiting for it, then they have approached the court for cancellation of that agreement. If you make construction, then it will frustrate their suit.
And my lord, in this type of contract, my lord, when there is a scope of extension of time, then my lord, time does not remain the essence of the contract. The only.
No, not for projects under RERA. If the project is registered under RERA, then time is an essence of contract. You can't take a plea that time is not the essence of contract. You see, that is with regard to that was a principle which was laid down in the I won't forget the name. I forgot the name of the case. 1976.
79.
Huh.
Then I was some.
Huh. So that principle will not apply in a place where people have parted with their land, waiting for construction to come up and get back a flat.
My lord, there were certain, these things when the suit comes for trial, man, we will also establish with evidence that what were the bottlenecks we had faced, my lord.
But for the time being, we are not interfering with the injunction. That will prejudice the plaintiff more.
But if the constructions are stopped, my lord, then.
No, the injunction is only on the suit land of the plaintiff, which is B and C.
This is the big difficulty, my lord. With the consolidated project, as I have shown from the photograph, my lord. It will be very difficult to chalk out a particular portion and.
No, you see, what Mr. Roy has said, plot ABCD, it has been clarified there. Because if that be the situation, so far as the rest of the construction is concerned, you can go ahead.
That may be clarified. That may be.
Because if his land is B and C, you can't have an injunction against. And Mr. Roy, how do you say it is B and C? What is the basis of saying that the land is B and C?
But if I measured my land portion of two lakh, it was found that it is read about B and C. So I have made a variant in my memo appeal also. Lordship, entire case of the builder is based on fraud. That's why not registered under the RERA. The RERA authority has imposed penalty of rupees 20
No,
lakh.
that may be, we are not on that.
The appeal was filed before the RERA authority, Lordship. That has been also dismissed. I have annexed all those documents.
That is,
And regarding subsequent events, Lordship, if my learned friend submitted that in the memo appeal, I have taken new ground, which are not mentioned in the injunction application, Lordship, or the memo injunction application, Lordship. So all those are the subsequent event, imposition of the penalty by the RERA authority upon the builder, then filing of appeal before the
Mr. Roy, still it will be very difficult to accept it.
Lordship.
Without amending the plan, new facts, it will be introduced in the appeal.
Lordship, there is a Supreme Court decision regarding subsequent event. That judgment is based upon after consideration of the 12 numbers of the judgment of the.
Pass it on.
Lordship.
Pass that because I don't have my type today.
Citation is Lordship 2004 8 HCC 76. I have come with it. 2004 8 HCC 76. Lordship, I'm pleased to come to para 16. Before that, para 16, in para 15, the apex court has held that the High Court wrongly not accepted the subsequent, consider the subsequent event. Then finding starts from para 16. Up to last part of the judgment, 7, 8 pages, Lordship, the apex court let down the law regarding the subsequent events. And in all subsequent events,
Just a moment, just a moment,
the petitioner participated.
just a moment. Mr. Roy, I'll tell you a background. Under the Uttar Pradesh, this Valia Act, so far as the commercial shops are concerned, they are not transferable to a legal heir. Tenancy is not transferable, just like Assam. Assam has a tenancy which is transferable and heritable. There is a judgment of the Supreme Court. Here I will forget it. It's 96 or 97, where it is said that commercial shops, they can't be a inheritance, and therefore the court takes in a eviction suit. The subsequent development where what had happened was that both sides had died. Their 3 legal representatives and 2 legal representatives were brought on record, and the plea taken was that the shop was locked. So it is that subsequent event which the Supreme Court says should have been considered, because even in the Assam, subsequent event is is an acceptable proposition, because after this Nityananda Banik, the duty of the tenant to pay tenancy even during the appeal is an acceptable proposition of law, and therefore subsequent event, insofar as defaulter is concerned, can be taken into account and decree be passed. So it's not foreign, because this relates to a eviction suit, where subsequent event, where the plea was taken that the shop was locked, was taken into consideration. So in the eviction suit, taking the subsequent event into consideration is an acceptable position. But it can't happen in a regular suit, in a title suit. You can't play in a regular title suit, not being an eviction suit. You can't bring subsequent event into consideration without amendment of the plaint.
The ratio of the
No, the issue is, that's why I told you the story. I have started with the act of eviction and I have ended it with the eviction suit.
the eviction suit also, Lordship, a tenant is bound to pay the rent till the final.
So even our court has accepted that position. Nityananda Banik is a leading example, where subsequent event has been taken into account.
Decisions, Lordship, that the tenant is bound to pay.
No, I get it. I'm not going on Supreme Court judgment when we have one of our own court.
But Supreme Court judgment will be binding.
No, I'm not saying not binding. Please don't misconstrue my statement. It's just like a political statement given in a what you call TV debate, and then starts what is the meaning of that debate. I'm not on that. You see, when I have my own judgment of this court, I need not go to the Supreme Court for the same ratio. So far as eviction suit is concerned, but in a regular title suit, a subsequent event without there being a pleading can be taken into account. That is something you must show us. The authority which you have shown is not a authority on that point. But still, Mr. Rahul, despite that, whether it is there or not, but the fact remains that if there is no construction on the land, that means even if today 8 floors are to come up, it will take at least 2 years more.
Lordship will be pleased to consider that the respondent is a widow. She is having land measuring 4 kattha and half lesser, Lordship.
Just a
He
moment.
had given the land to the builder in 2015.
No, I'll come to you. Let him complete. I'll come back to you. Mr. Roy, I'll come back to you. Let him complete. Let Mr. Rahul.
The regime of adequate compensation will always be there. And their purpose will also not be served. A half-done project, nobody will be able to come there, and it is a contiguous project, my lord. And even if they take the land and give it to someone else, or it may have someone, let us think practically. Then also, my lord, they will face difficulties. And these all.
No, these are all ifs and buts. Correct. We can't go on those propositions, because if you take this plea, you'll find it judgments I won't remember. There is a decision of the Supreme Court of India in 2 cases. One is some motors. It was earlier situated in Connaught Place. In an eviction suit, the Supreme Court carved a exception, saying that the present market value can be considered by a court. That is one perfect models or something. It was in the Connaught Place once. That is one. Second is a case of Salman Rushdie. There are land in the Lutyens area of Delhi. The price of the land, the Supreme Court enhanced it by more than 20 times, taking into value the current scenario. Salman Rushdie, that famous author. That is one case. But that's apart. You see, today land of 4 kathas, 4.5 kathas, almost a bigha. The value of the land would be enormous.
But
So if you are withholding that property, you are in fact by way of escalation, you are benefiting at the cost of the petitioner, respondent.
in my respect to this decided at the final stage of the trial, then, my lord.
It's okay, but I am not inclined to interfere with the injunction,
They are just pay them the suit land, the suit property which they have. lent.
except what is there of the petitioner. There you can go ahead with the development.
All the landowners have filed these.
So I don't know, but that is, no, it's okay. They all may have be fighting. But here I am concerned with only the respondent. We are upholding that injunction, but for the time being not interfering with the injunction, but we are saying that construction on other plot may go ahead. But Mr. G. Rahul, counsel for the appellant, petitioner, as well as Mr. S.P. Roy, learned counsel for the respondent. Sorry, it is petitioners, as petitioners, and Mr. Roy for respondent. Next matter. By filing this application under Article 227 of the Constitution of India, the petitioners have assailed the appellate judgment and order dated 13/7/2023, passed by the learned Additional District Judge number 3, Kamrup Metro, Guwahati, in Ms. J case number 97 of 2021, in Miss within bracket appeal number 93 of 2021, who stopped by the said order, ad interim injunction was allowed by the learned First Appellate Court to restrain the petitioners, their servants, employer, it should be employee, EMPLOYEE, workmen and agents and associates, from doing any construction over the suit land belonging to the petitioner and changing the nature and character of the suit land, and also encumbering the suit land in any manner till conclusion of trial of TS number 61 of 2018, pending before the court of learned Civil Judge number 3, Kamrup Metro, Guwahati. Next paragraph. The petitioners are carrying out land development and construction of apartment flats in the on the land of the respondent and other another owners of contiguous plots of land. By virtue of a registered agreement dated 19/2/2015, the respondent, with a grievance that the construction has not come up within the agreed time, and on other grounds as pleaded in the plaint, the respondent had filed a suit against the respondents for declaration, cancellation of the agreements, registered agreements.
Respondent filed the suit against the project petition.
What did I say?
Probably your lordship has said respondent.
Okay, respondents filed a suit against the petitioners for declaration, cancellation of the agreements, recovery of possession and permanent injunction, which was registered at TS 61 of 2018. And pending for trial before the Court of Learned, Civil Judge number 3, Kamrup Metro, Guwahati. Full stop. Along with the suit, an injunction application was referred by the respondent of the order for order 39 rule 1 and 2, read with section 151 CPC, which was registered as Misj case number 135 of 2018. Full stop. On refusal of injunction by the learned trial court, comma, an appeal was preferred, which was registered as this appeal number 93 of 2021. By the impugn order, the learned trial court, the learned first appellate court had granted injunction. Against the said order, this revision petition has been preferred by the petitioners of the defendants. The learned counsel for the petitioners has submitted that the learned first appellate court relied on statements made in the memo of appeal, which are not pleaded in the plaint or in the injunction application, and therefore the learned first appellate court had committed gross error and jurisdictional error in granting injunction based on facts which are foreign to the pleadings made before the learned trial court. First off, it is also submitted that there is already a delay in the execution of the in the construction of the project, and for the and there would be further delay in the completion of the project in view of the injunction. So it is submitted that the plot of land of the petitioner is within the contiguous plot in which the proposed constructions are coming up in 6 blocks, which for the sake of convenience is referred to as block A to block F. And it is submitted that if any portion of the construction remains incomplete, comma, there will be difficulty in timely completion of the project. Next, issue notice returnable. Issue notice including notice on the prayer for interim relief returnable in 4 weeks. First, a notice has already been issued. It has come for admission. Okay, next one. The Mr. Roy, this has come for admission. With that modification, I can dispose it of. Yes, Mr. Rao.
Only one prayer, Lordship. If your Lordship passes the order that for other parts of the project, the construction work, but other landowners have also obtained injunction. Like
it is for them to come up. If this order is contrary to their interest, they will come up.
Okay.
I'll just take a 2-minute break and come back. the learned counsel for the respondent, by referring to the affidavit in opposition filed in this matter, has submitted that that despite the agreement between the parties, the construction project of the petitioners was not registered in with the RERA. This is what is the full form? Real estate regulatory authority.
Real Estate Regulation and Development Act 2006.
Regulation and Development Act.
2006.
You'll get the full name, huh? RERA Act. And he has also referred to an inspection report dated 1/4/2023 conducted by the RERA authority, GMC and GMDA, where the present status of construction as on the date of the report was stated as follows. Page 164. There's a block. Page 164. There's a column. Accordingly, it is submitted that the present status of construction is that the project is still incomplete. Reference has been made to the action taken by the RERA authority and facts relating to another plot holder which is not referred to here herein because of the same not being a part of pleadings before the learned trial court.
So we have filed these documents before the learned trial.
Where is that?
These all subsequent documents have been filed.
No, your written statement is there. It is not there. I've read your written statement.
Court I have.
No, I'm in the trial court.
Sorry.
Nonetheless, comment is submitted that as there has been an inordinate delay in carrying out the construction of apartment flats on the land of the petitioner, the land of the respondent, the learned counsel for the respondent has justified the order of antedatum injunction granted by the learned first appellate court. Next matter. Therefore, the only point for determination which arises in this revision is as to whether the appellate order of injunction is liable to be interfered with in this revision application filed in Article 227 of the Constitution of India. Next paragraph. Having seen that in the written statement filed by the respondent, the subsequent events which has taken place at the instance of RERA have not been pleaded. The court takes the court is in agreement with the submission made by the learned counsel for the petitioners that the argument made by the respondent in the before the appellate court was not a case pleaded before the learned trial court. Full stop. In this regard, just give me your citation that in this regard the learned counsel for the petitioner.
2004 8 HCC 70.
Just give me, because I have to make a mention since you have made a reference. As referred to the case of Kedarnath Agarwal, within bracket dead, and another versus Dhanraji, Dhanraji, Devi, within bracket dead, by LRs, and another, comma, within bracket 2004, bracket close, 8 SCC 76. And he submitted that subsequent that it was permissible for the learned first appellate court to base its order on the basis of subsequent events. So next, having regard to the judgment rendered in the case of rendered by Supreme Court of India in the case of Kedarnath Agarwal, within bracket dead, and another within bracket Supra, it is seen that the said suit was a suit, the concerned suit before the learned before the Supreme Court of India was eviction suit based on landlord-tenant relationship. Full stop. It is too well settled that in a case of eviction of a tenant, comma, to a certain extent, the subsequent events can be considered. Full stop. In the said judgment, the Supreme Court of India has discussed several citations. So all the cases referred therein relate to landlord-tenants relationship. And the discussion on the case laws was based on the fact that the crucial date for deciding as to the bona fides of the requirement of the landlord is the date of his application for eviction. But subsequent development during post-petition period can be taken into account for judging the bona fide requirement pleaded by the landlord. However, with due regard to the case cited at the bar, the court is of the considered opinion that the same principle would not apply to a regular suit relating to declaration of right, title, and interest, recovery of possession, and cancellation of deeds. And therefore, recourse must be taken to the provisions of Order 6 Rule 17 CPC to bring subsequent events to be brought on record by way of amending the pleadings. Full stop. However, this issue relating to taking into cognizance subsequent events is being distinguished in this order on the basis of a suit for eviction of a tenant, as well as and a suit relating to a declaration of right, title, and interest. And therefore, subsequent the requirement of considering the subsequent events are on two different set of two different parameters. Next paragraph. Having said so, the court finds that as per the deed of agreement dated 19/2/2015 is concerned, the said agreement envisages construction to come up within a period of 36 months, right? Full stop. We do not intend to delve upon the requirement, DELV, on the requirement of law as to whether the time is an essence of the contract, which is left open to be decided by the learned trial court. Stop. Nonetheless, as per the inspection report dated 1/4/2020, for 2023, from the statement made at the bar by the learned counsel for the petitioner as well as the respondent, that the plot of land of the petitioner would be relatable to block B and C mentioned in the said report. The court finds that the progress of the construction does not envisage an earlier completion of the project on the land of the petitioner, which is measuring 4 katha, 4.5 lecha, covered by dag number 531 within bracket old, oblique 342, comma 343, comma 598 within bracket new of KP patta number 33 within bracket old, oblique 932 within bracket new of village Gotanagar, GOTANAGAR. Full stop. Next one. Therefore, comma, when the respondent as plaintiff has filed a suit for declaration to declare the agreement dated 19/2/2015 as to be cancelled for recovery of possession and permanent injunction, comma, the non-granting of injunction would cause prejudice to the respondent. Which is considered to be more than the comparative loss that the petitioners would suffer, considering the fact that the proposed construction is still incomplete even after a lapse of 8 years.
I submit online lot. Any builder is not registered the RERA. The builder cannot sell or book advertise for the sale of the flats as per section 3.
I am not quoting those words here.
No, the learned trial code held that the builder will suffer irreparable loss. So he has no right under the RERA to
I
sell that.
agree with you.
So there is no question of suffering.
I agree with you there, but that's why I'm not. But I'm not putting words here. Because to expunge these words, he has to go to Supreme Court then. I'm not putting words which would prejudice the petitioners. No, it's okay. Justo. Espera, in view of the discussion above, comma, the court finds that the that that it cannot be accepted. It cannot be said that the learned first appellate court had committed any jurisdictional error in in its appreciation that the respondent had a strong prima facie case for trial. And that the balance of convenience tilted in favor of injunction, as the respondent was not in a position to do anything over a plot of land or to sell her, but to wait at the mercy of the petitioners to have her flat, have her promised flat. Full stop. The finding of the learned first appellate court on irreparable loss and injuries, which the respondent is likely to suffer, it is also not found to be vitiated by a judicial error. So therefore, the court is disinclined to interfere with the impugned order dated 13/7/2023, passed by the learned additional district judge within bracket FTC, bracket was number 3, Kamru Metro Guwahati. In Ms. case number 97 of 2021, arising out of Miss Appeal number 93 of 2021. Next para. However, before parting with the records, the court is inclined to observe that the learned trial court, as learned first appellate court, had granted injunction limited to changing of the nature and character of the suit land, and also from encumbering the suit land in any manner. Therefore, the court is inclined to observe that the said order of injunction shall not preclude the petitioners from carrying out construction in any part of their project, save and except construction on the suit land which is described in schedule to the 10th. According to this, appeal stands dismissed with clarification to the extent of
Place of appellate, it will be petition.
petitioners with clarification as to the effect of the order of injunction as indicated above. So the parties are left to bear their own cost. This citation you collected after some time, after I transcribe it. Item 3.
Timing item 3.
Yes, Mr. Bhatti.
My lord, item number 3 and 4 are similar.
Yes.
My lord, in this particular case, I have filed the amendment petition matter. I have filed the amendment petition matter under order 1/10 for adding inland waterways of India as one of the legislative parties matter. That, my lord, that application may kindly be allowed.
This is a revision application.
Yes, indeed. Under Article 227.
This is against which order?
Against the order, my lord, your lordship will find the order at page 27.
27.
And my lord, that is the reference case, my lord. By the recent decision. And that was rejected on two grounds, my lord. The first ground, that the reference is time bar. And secondly, not going of necessary party. It is the inlet, whatever is also that your lordship will find at page 27. It will start from 28.
No, you see, in this matter, I had not been able to follow. This is a land acquisition application which was rejected.
Yeah, but-
So if there's if there is a rejection decree, you'll have to file an appeal. How this revision would lie?
No, my lord, but there was decree now. It is under the Assam, sorry, Acquisition of Land Act. So I think it's already for that. Land Acquisition Act, 1989.
Assam land laws.
No, Land Acquisition Act, 1894.
Land Acquisition Act.
Yeah.
LA Act. No, not this. LA Act. LA Act, is it not a decree?
No. According to me, my lord, there cannot.
See, please see what is 54 then.
Yes, 54. If before my lord, appeal in proceeding before court. Subject to the provisions of the court of civil bill applicable to appeal for order not anything
54 is appeal.
for the time being in full. An appeal can only lie in the procedure under the section. Yes, I.
So we close it with
Yes,
you.
let it be converted into an appeal.
No, for appeal, you'll have to give a certificate and then produce, file it in the proper manner. So you'll have to withdraw it and then file it. You'll permit that.
Yes, in that case, my lord, we divide it here.
We'll give you, and we'll ask you to take back the certificate copy and the wakalatnama. Okay.
Both the cases may be disputed.
Yes. Have Mr. O.P. Bhati, learned counsel for the petitioners, as well as Mr. K.K. Bhattacharya, learned government advocate, appearing for the respondents. Next para. In view of section 54 of the Land Acquisition Act, 1894, the learned counsel for the petitioner placed liberty to withdraw this application and to approach the court in an appropriate appeal. Fair is allowed. The learned counsel for the petitioner is granted liberty to withdraw the certified copy of the impugned order as well as the wakalatnama by providing a photocopy thereof to be retained in the record. With liberty to approach again, the matter stands closed.
But
Both items 3 and 4.
Another benefit case, item number 13, what had happened, the case is over, my lord has passed order, I have no grievance. Only thing I'm informing certain things. What has happened originally, the condonation.
No, you, that was a matter of, you please call the council, I'll hear you. Call the council.
No, my lord, I'm informing certain.
No, you see, no, Mr.
Bhattacharya.
Bhattacharya, please understand my position.
Not been served of the.
No, it's okay.
Actually.
You call the council is on record, you please call him. I am not permitted.
My lord has called the record, I can do it next day. I've informed the court.
You tell him, we will give you a copy.
That is all. That is why I could not appear.
No, that is okay. But you understand my position. I can't hear against somebody.
Item 16. That is it.
Yes,
In this matter, we are supposed to file document relating to the bail ownership, but there is no instruction till date. So some,
take it up after 2 weeks, Mr. Ahmed. Well, on the prayer made by Mr. A.K. Sharma, counsel for the petitioner, list after 2 weeks. So as to enable him to obtain instructions. Mr. F.K.R. Ahmed, counsel for the informant. And who was the PP here? As well as the learned APP are present. List after 2 weeks. Okay.
17.
There is no representation from the appellant. For injustice, justice, the matter stands adjourned today. List after 2 weeks.
18.
Just a moment. List after 2 weeks. Under order for hearing under order 41 rule 11 CPC.
18.
Yes.
This matter may be listed along with RSL number 90 of the 2000 same set of judgment. Same set of judgment. And this RSL 90 already admitted, same question of law will be failed. RSL 90 of 2013.
Just a moment. You have a copy of that order?
Order I don't have, but I have the appeal I have to. Same,
No,
same, everything.
Just a moment. Okay, this on the prayer made by Mr. B. Sinha, counsel for the appellant, list the matter after a week. Along with the record of RSA
90
90 of 20
2013.
or 2013. You have anything to say for the respondent? On the submission made by Mr. Sinha, do you have anything to say? Okay. Counsel for the respondent is present.
19.
19. Yes.
But now the service on the before it said that it has been returned back. As office note dated 23/11.
Yes.
And regarding our 2 and 3, office note says that they are not furnished the copy of petition and annual. Those are earlier submitted as per.
No.
No, as per office note dated 16/8/23, they said that I could not furnish the return of notices. That's why the notice could not be sent. So later on, I submitted the notices.
No, because you see, unless we permit you to use the earlier envelopes, it will not be sent. You will have to give full particular full.
Otherwise, these all these three are all the owners and drivers of the return. They are otherwise also not supposed to appeal notice because that during the trial also the case proceeded expert.
No, you can, Mr. Gaur, you can make a prayer to strike them out. I can accept it. It's okay. Who are those 2, 3, and 4?
Who is
Uh,
the driver, owner of the pending vehicle? He is the driver and 4 is the owner of the scooter.
This is a appeal for what?
The award was passed against the owner of the vehicle. So against the owner of the, my lord, has to be against the insurer of the vehicle. And my lord, for any reason. Owner has not come.
No, I don't know. You take a call because if the driver and they are not there for enhancement, whether you will suffer prejudice or not, I don't know. I won't make a comment. If it's a prayer for enhancement, whether driver is a proper party or not, I forgot.
No, my lord, the issue is, my lord, regarding the, my lord, at the stage of the argument, my lord, during the trial, the OP number 1, my lord, submitted a witness, my lord, that they wanted to examine a witness only on the point of, my lord, to exhibit the policy, my lord. And they exhibited the policy, my lord, that policy is different from what the policy number has been furnished, my lord, in extent information report by the police, my lord. So I have taken that ground, my lord, the London trial court has not considered that. So if the policy number which was taken, written in the, my lord, the accident information report is taken up, then, my lord, certainly the exhibited policy which exhibited by OP number 1 does not have any, my lord, relevance.
Okay.
The order was passed against the owner of the vehicle. They have not come. So they may not, otherwise also, my lord, suppose this case is going on, the claimant will not get anything, my lord. Suppose, even if, my lord, this case is going on, and they did not appear, the owners are, the claimants are not going to get anything, my lord. Award was passed in way back in 2009, my lord. Now this.
That's okay.
At the record says, my lord, that they did not file WS, my lord. After, my lord, examining at the stage of argument, after examining the, my lord, the witnesses, they were taken a plea that they have filed the written statement. That was not there, my lord.
No, that's okay. You see, I'm only concerned with your prayer for enhancement. If the judgment is against the owner, and they are not before us, you take a call because I can't say.
Because, my lord,
Huh?
they may be, their name may be. The name of the owners and their may be, my lord, deleted.
It can be deleted. Okay. On the prayer made by Mr. J.C. Gaur, London Council, for the applicant, the name of opposite parties number 2, 3, and 4 are struck off. Full stop. As the opposite parties number 1 and 5 are duly represented by Mr. K.K. Bhatto and Ms. M. Chaudhary, Learned Counsel. Let this. Then this is a delay of condemnation. How many days? 1?
1541.
1541. You have to show some good cause.
My lord, it is, my lord, taken the ground, my lord, that the claimants after, my lord, the incident, they waited for some time, my lord. And thereafter they went to their native place in Haryana, my lord. And so that when the award was passed, they could not be informed. After, my lord, many years, they came back to Guwahati to attend a marriage, my lord. Only at that time they contacted me and I informed them, and they instructed me.
But that do not constitute a good ground.
My lord, proceedings see that, my lord, this is the only earner of the family, my lord. After his death, my lord, there was nobody to look after them, my lord. So they have to leave Guwahati for their native place.
No, you see, that is something else. But once a claim is filed, and then after 1341 would be about more than 4 years.
My lord, the award was, my lord, the accident taken place in the 2001, my lord. Award was passed in the 2009, my lord, after 8-9 years, my lord. So how long they have to wait? The proceeding has taken too much long time.
But this explanation can't be accepted.
In my lord, the ground taken by the limit court below. That written statement was filed and it is all, these are not, my lord, if on prima facie, my lord, its policy shown by the OP number 1 is not there, my lord. In that case, the OP number 1 was supposed to, my lord, discharge the payment, my lord, administrative payment under the one. And in the motor, this provision was for benefit of the claimants.
I understand, but there must be some good reason assigned.
This was the reason.
They merely say that on 12/1/2008 you left Guwahati, and then you came to know in 2014.
No, they came to attend the marriage, my lord. They came to attend the marriage in the at Guwahati.
So this can't be acceptable
This is the
ground.
real from, my lord,
No, it's okay. You see, I'm not questioning the questioning you, but the ground must be reasonable. It has to be an acceptable parameter.
Let out ground on the ground of my lord.
No. You see, Mr. Gaur, I'm not accusing you of making up a story. But I must accept it as because I'll be laying down a law and I'll be bound by it thereafter. You see, merely by saying that the party came after 2008 and 14, 6 years. If I accept that, then what is wrong in accepting the statement of insurance saying that they had to move the file from table to table and then file an appeal after some time?
Normally, the limitation on the part of the insurance.
No, not before this bench. I am not so very lenient when it comes to the insurance company. In a given case, I have deprecated the use of these words. File was moving from table to table. I have taken an exception to that.
It has to be, my lord, this case.
The parameters must be same for both, even for claimant and even for the
This is the
insurance. No, but I'm sorry, Mr. Gaur, this is not acceptable. There's no particulars given.
The particulars, my lord, I think I can, permit some time, I can.
No, you see, if the lawyers, if you have,
Card also, my lord.
if you have left the place without informing the lawyers, then the lawyer had no duty to inform you.
My lord, I could have informed, but my lord, I am not aware of them on this.
No, but that can't be an excuse.
They waited for 8 years, 9 years. Moreover, my lord, earlier there was a limit for filing MSAT cases. After amendment, I think there is no limit also. Earlier there was a limit of 1 plus 6.
But the appeal has some limitations.
It still has the limitation, but.
Appeal has some limitations.
Socially beneficial legislation, keeping that view of the matter.
Mr. Gaur, we permit you to show us any case law or something by 2 o'clock, because this is otherwise I am not accepting it
Some other day.
some other day. Because I am not convinced with the vague explanation to condone a delay. First part is over. As the explanation to the delay is not very convincing, the learned counsel for the petitioner plays for some time to address the court and supplement his submissions with case laws. Mr. Matter stands adjourned today, list after. You see it after a week, list after a week. Be prepared on that point, limitation. Maybe next week.
20.
20?
Yes.
Yes.
Or responded to last occasion, that is the last day 1610, just to be directed to take the step, respondent number 2. They have taken the step, but on 1710, on the next day. Well, this is the register.
When did you take?
I have taken, my lord, I have a receipt, you see.
1710.
1710, my lord, in regard to the respondent number 2. Owner of the receipt. My lord, I have the receipt for the night. But it's not reflected in the.
No, it was rightly not issued because I said on the same day, you did not take steps on the same day, you take it after a day.
Not taken on the same day. Although I've taken on the very night. Register the date.
Mr. R.C. Paul and counsel for the petitioner has given an explanation for a 1 day delay in taking steps in terms of order dated 16/10/2023 by submitting that instead of taking steps on the same day, steps was filed on 17/10/2023. Mr. C. Gogoi, counsel for respondent number T. Okay. For counsel for respondent number 1 is present.
Yes.
Next para. The next para, the delay taking steps by the applicant is condoned. Next para, the registry shall now issue notice on the respondent number 2, which is made returnable in 4 weeks. Give a date. Give a date after 4 weeks.
6th of January.
6th of January.
Totally Saturday.
501. 51.
5/1/2024. Based on so-and-so awaiting service of notice on respondent number 2. Respondent number 2 or 2 and 3?
He is the driver of the vehicle. Direction was made on the step on the respondent number 2.
Where is the order of the court allowing you to take only on 2, not on 3?
That is 1610. Order. Order 1610.
No, 1610 is because in the last date we are referring to respondent number 2. But it was never pointed out that respondent number 3 is there and no notice was issued on them.
I'll
take it within 3 days. I take that step. That's one number. Register with it.
But Mr. Paul, you should tell us that what has happened. You see, it is by matter of my habit that I am looking at the cost title and finding out whether it is there or not. These are something to be done by a lauzima. If I spend my time looking at who has done service, on whom service was not made, on whom steps is not given, then not more than 10 cases I can dispose it of. I'll be sitting as a lauzima court. Please don't convert me to a lauzima court just because I am doing it. It is my trial court habit to see whether the service is complete or not. I am doing it. But I must shed off my trial court experience here. You are there to assist us. One by one, you will say, I'm taking on number 2, then you say taking on number 3. If that is the way I am to proceed in a high court. No, it's not there. We'll close that chapter. Why should we give it more time? We'll strike it out because it's not the way. If you don't assist the court, why should I be so lenient on you? Steps has not been taken on respond number 3. The name of respond number 3 is struck off at the risk of the appellant. This one so awaiting service of notice on respond number 2. When we were in court till the other day before my elevation, the first thing was that to record the record, to assist the court in telling the court whom service is made, whom it is not. That was the first job. Just even prior to elevation, I was doing it. So why you should be be complacent in not looking at the in the orders and note sheet? Why you leave it everything with the court? If you don't assist the court, adverse orders. We'll continue that too. Mr. Jain, you have stood up. You have to say something? At 2 o'clock. I may be 5 minutes late in coming. Both sides are represented on the prayer made by Mr. K. Gogoi, Leonard CEC, and residents adjourned today. List on. Agree to a date?
Next week. On
7th is a Thursday. Make it 6th or 8th. 6. Yes.
Well, I have gone through the plane, but that thing is not there that I have denied that family person putting the city does not belong to me. But they may, in the WS, they have made a counter claim. In counter against the counter claim, I have filed WS, and that is their matter.
Where is that?
So that is also part of pleading.
Where is that?
Yes, but that is not. Actually, I did not.
You need to bring it on record if it is there.
Yes.
No, it's okay. Not required. Not required. I take your statement at the face value.
Additional affidavit.
Okay. I take your statement at the face value. On the prayer made by Mr. M.U. Mahmood, counsel for the petitioner, he is permitted to bring on record additional document on which he wants to rely on by way of an additional affidavit. List on when?
Friday.
Friday. Okay.
Item 21.
Proceed, 2 and 3 my lord. For now, 2 and 3 minutes from the list. 2 and 3 my lord. For number 2
Struck off.
3. My lord, actually, we have gone through plan, my lord. We have filed on quantum and.
No, it's okay. I don't want a reason.
My lord, we have already contact with Royal Sundaram.
No, it's okay. Once you are making the statement, no point of hearing on that. Upon instructions, Ms. L. Sharma and counsel for the appellant seeks liberty to praise for striking out the names of respondent number 2 and 3. First of the Mr. B.K. Jain, learned counsel for the respondent number 1 has no objection. First of, therefore, name of respondent number 2 and 3 is struck up at the risk of the appellant. This will come in admission now. It'll go for hearing. LCR has come. Okay. As the LCR is received, list the matter for hearing in the month of December 2023.
Oh, this one.
22. Just a moment. Yes.
Take steps of the respondent to personal publication.
Yes.
The paper application was already been made. They also filed an additional activity to that on 24th, but the record has not come in.
You filed it.
But I filed on 24th.
But it's not here.
It's not come on record.
Acha, okay. Mr. M. Smith, counsel for the applicant has submitted that an affidavit of newspaper publication of notice against respondent number was against the sole opposite party has been filed, which is not on record. Which is filed on which date? 24/11/2023, which is not on record. Post of the registry shall tag the said affidavit on record and list the matter again.
$23.
Yes.
The last take step on statement say for the statement and to this step. I also inform the insurance company. But when I am not civil service, I will find the affidavit.
Okay. Mr. R. Sharma, counsel for the appellant, pays for some time to produce the proof of service of process on respondent number 3. Miss,
So I'm appealing for response.
name.
Indrani Kumari.
Indrani Kumari, counsel for respondent numbers 1 and 2 are present, is present. List after 2 weeks.
Fine.
24.
Yes, Mr. Swami.
I will put the instructions. We will get the after 2 days. What will happen in this case? Respondent 5 and 6 is the same person. One was interior driver and the owner.
Okay.
Respondent 5 has died. There is a direction to confirm that whether 5 and 6 are the same person and also the legal after a certain.
Okay. Okay. On the prayer made by Mr. R. Goswami, counsel for the applicant. List after a week so as to enable him to obtain instructions.
25.
One LCR report is not found minor for a long time. That is why the title should frequently. The title appeal reports is attached. So remember what's saying several times. There is a last minor report. 2011-2023. Like.
Maybe it is there in the appellate. 77018. Just wait for some time. Wait for some time. Let me make an inquiry.
26.
The official date is 23/11.
We'll ask the Laozima to take a call on the service.
My lord. I think, my lord, since the office notice is very clear, lord, maybe avoid it proper on number 4 is concerned.
No, we'll send it to the Laozima. They will take a call.
That can,
Notice has been issued on 8/11.
right, 8/11.
So, not before 11/12, 30 days deemed service can be made. Mr. S. Dastal and his senior counsel for the applicant has referred to the office note dated 23/11/2023, wherein it is observed that AD card of respondent number 4 has or unserved notice has not been received. Full stop. As next para, as notice was issued only on 8/11/2023. Let the registry await service report till 11/12/2023, and thereafter the matter be sent to the Laozima court. And if unserved notice or AD card is not received, then the matter will be listed before the Laozima court for passing appropriate orders as regards service of notice on respondent number 4. Mr. S.S. Roy, learned counsel for respondent number 3, and your name?
You won't be.
You, Rompi, counsel for respondent number 1 and 2, you are present. List accordingly.
28.
Kindly speak of respondent number 2 and 3, my lord. Driver and owner, my lord. They are not necessary parties.
Okay. Upon instructions, Ms. L. Sharma, counsel for the appellants, praised for striking out the name of respondent number 2 and 3. Ms. S. Kotaki, counsel for the respondent number 1, has no objection. So accordingly, the name of respondent number 2 and 3 are struck off at the risk of the appellant. LCR is received. Okay, as LCR is received, this is the matter in the month of December 2023 for hearing.
Yes.
Yes.
Your lordship. Office note dated, my lord, 21/11/23. Service is complete, my lord.
Service is complete.
There has been received.
Mr. T. Kalita, counsel for the you are appealing for respondent number 3. You are appealing for 3. Oh, okay. Counsel for the appellant, respondent number 1 and 2, as well as respondent number 3 are present. So, Accordingly, case is ready as regards service. And the LCR is also received. So accordingly, this is the matter for hearing in the month of December 2023.
Okay. 30.
Yes, what has happened to Deputy Commissioner?
Lordship,
No progress.
we have received this letter. Not actually trace of the record. Because it's very old. After deputy commissioner office was shifted from here to.
Now, I was just noticing Mr. Sinha's shoe sole is getting eroded.
Understanding.
Grip of his sole is. You've seen his.
Totally understand.
So then, what to do for Mr. Sinha?
But in my humble submission, we have totally communicated the department and now the department.
No, that's okay. Now he is personally getting affected. The shoe soles are starting to. What would be the equivalent of Assamese word khoi goya se? What would be the equivalent word? No, so what is the English equivalent? Okay, we'll give you one more chance. Otherwise, we'll have to close it. We see on record one last chance. Just, we are waiting for about more than a year.
Because in fact, finance department also can produce that dispatch and receive page them.
No, you see, you have the liberty of communicating with them.
Had communicated, they had not officially of course, but they have now said that we have not received this letter. But that actually should not be the case because these are responsible to the government departments.
I understand, but the
Just by lifting the blame, in my humble submission.
no, that is okay. But interdepartmentally, you'll have to settle it. You'll have to call these people and have it settled, because we can't punish Mr. Sinha for that.
I understand you, but because your lordship.
You want an observation from the board to allow you to interdepartmentally communicate? Okay. Both sides are represented. Mr. D. Bora, learned counsel for the learned government advocate, has produced a copy of communication dated 17/10/2023 received from the office of the district commissioner, Kabro Metro, to the effect that the relevant records referred therein could not be traced out, as the communication in reference was made about 16 years ago. Stop. Next paragraph. On the prayer made by government advocate, for last opportunity is granted to the petitioner to produce the relevant record as per earlier order of the court. Stop. The petitioner is also permitted to make interdepartmental communication so as to enable them to track the copy of the relevant record. So next paragraph, it is made clear that if the relevant records are not produced, The court will proceed to hear the matter on the basis of materials available on record. Based on, give a date after Bihu, January. The communication produced by the Honorable Government Advocate is returned. So what at the last opportunity? Last one. 31.
As per the office note dated the 22/11/2023, respondent 1, respondent 4, respondent 5 has been duly represented by the learned counsel. Whereas as per the process server, notice of respondent 2 was received by father and notice of respondent 3 was received by daughter. LCR has been received, Your Lordship. Your Lordship, if all the respondents are served, then the matter can be put for hearing.
Okay. We are appearing for
1 and 4, Your Lordship.
1 and 4. And you are for 5. Okay. The petitioner, respondent number 1 and 4, as well as respondent number 5 are represented. As per the office note dated 22/11/2023, process issued on respondent number 2 and 3 were received by their father and daughter respectively. Full stop. Accordingly, notice is deemed to be duly served. None appears on call for respondent number 2 and 3. Full stop. As the LCR is received, this is the matter for hearing in the month of January 2024.
Right.
Article 3.
Oh, so it was 24.
Just yes.
That's the office code that is 24. All service users, made on service users now, maybe card opening.
Okay. Councillor, the appellant is present. As in view of office note dated 9/11/2023 and 24/11/2023, service report on the sole respondent is awaited. Released on 13/12/2023 along with office note as regards service.
Okay.
34.
I'm appealing in this case, Lordship. Today I have received a copy of the appeal memo, Lordship, along with one IL. I need some time to run through the same, Lordship. After 1 week, Lordship, matter will be listed.
Okay. After a week.
Yeah, after a week.
Okay.
Yes, but that is an IM. What has happened? An inadvertent error has occurred in the affidavit which was filed in terms of your lordship's order.
There is no IA here.
It's item number 51 of the Supreme Court.
51.
So may I invite my lord's attention at page number 177, category of lordship's order 18/10/2023, at para number 20.
Just a minute. But let her go through it. She doesn't, she wants some time to go through it after a week.
Because finding terms in your lordship's order, that 611 was the.
No, it's okay. Let her go through it. She's wanting
That's
time.
my lordship.
Both sides are duly represented on the prayer made by Ms. P. Bhattacharya, counsel for the respondent. List after a week. Liberty to file objection if so advised. Interim order is there.
Order is there.
Interim order passed and stands extended to the next date of listing.
It is already admitted for hearing. It has been admitted. That is your lordship's observing.
It's okay. Once he is getting an objection, no point hearing the matter.
Give you.
Yeah, unless you commit yourself that after receiving an objection, you would not file any other pleadings. You will fix it for hearing. If you take that risk, we are ready to hear you.
That would be.
Yeah.
Thank you.
35.
Hearing or what kita man explain.
Yes,
Your application has been filed by the respondent number 3, my lord.
yes.
On the order passed by your lordship on 21/2023. Page 11.
Page 11.
One part, my lord, review with respect to paragraph number 3.
11. Yes.
Paragraph 3. Mr. F.U. Bormia, learned counsel for the respondent number 6, namely Govinda Dev, has categorically submitted that his client Govinda Dev is not the owner of the property in question. This part, my lord, is neither in the affidavit nor in the, because Govinda Das, original property was wife of Govinda Das. After death of Govinda wife, Govinda Das along with other sons and daughters were the owner.
No, but you look on a specific query. The statement came on a specific query.
But this part not
Okay.
affidavit in opposition filed by us.
No, may not be, but we rely on the, we heavily rely on the council.
But in fact, he is one of the owners.
Okay.
In
So
fact,
okay. So, so what is the extent of prayer made in this review application?
this part that he is one of the owners. And another paragraph, my lord, paragraph number 6. Can you see? On lordship from line number 4 below. On the race representation.
Page
11.
Page 11, paragraph
Paragraph 6.
6,
Page 12.
page 12,
Yes.
paragraph 6, yes.
From last below 4 line. On the phrase representation being submitted within 10 days from the date of this order, the executive officer shall hear the petitioner and concerned owner of the construction which is being made by the deceased wife Govinda Dev so and so. So my submission is that my executive officer is not the authority. Under section 177, board is the authority of the municipal act. Because there was an alleged violation of terms of the
Municipal Act. Assam Municipal Act. Section
177. Should a building be begun, materially altered or erected, come to D, in contravention of the terms of any sanction granted.
Okay.
Here is the allegation is terms of the sanction, we have violated and constructed the house. And another allegation is that
A without sanction as required under 171. So in that case, board is the authority. So only this limited purpose I have filed this review application. Board is to take this. 171 is the prohibition of building without sanction.
Yes, Mr. Banik.
Well, so far as the review petition is concerned, there are two things. Addressing this part will be touching the merits of the matter, number one. Addressing this part, because this error would not be error on the face of the record. The error which is pointing out as whether the board or the executive officer, this is not an error on the face of the record. This would be an error in law. Can they can appeal on that?
No. You see, the pertinent question would be that the order of the court should prejudice no one. If the law says that it is to be adjudicated by X, I can't direct Y to adjudicate it.
And if need be, I'll find an affidavit to it, because I got my response. But the point is, when they deny that I am not the owner, and then there is a change of the counsel, advocating for the earlier one, how far that is sustainable in law, because subsequent developments have taken place, the content has been closed, the orders have been passed by the authorities, writ petitions have been closed, I'll place them on record.
File an affidavit.
Yes, I have to.
Yeah, file an affidavit.
And there's a law, that statement made by a counsel in review by change of counsel is deprecated.
No, that's okay.
If a statement is made by a counsel on a pointed query by the court, I would understand the same counsel addressing the court on that here and there. I would not have much of say. But the writ petition was closed, directing something to be done, which was done. His name was struck off. It is not that he just shut down. His name was struck off by this order under review. Subsequently, many orders were passed. We had come in.
So you file an affidavit.
You have to file
Because
affidavit.
you do it.
Whether in review jurisdiction, so much can be done because contempt has also been closed now. After closing everything, now they come in review.
No, you see,
Second part is concerned, my lord.
you see, unless you point out, we have power to do everything.
Okay,
Unless you show us that we don't have power to do it, then it is okay.
That the power of review is there. The exercise of it in the facts and circumstances is subject to consideration.
No, incidentally, I can, although my handwriting would not be good, but I can write with my left hand also. You understand the meaning? Handwriting may be bad, but I can write with my left hand also. And in sports, there is one sport I can play with both hands. Two sports, in fact. One is chess, and one is table tennis. I can play with both hands. I'm just indicating. I'm not conveying anything. I'm just indicating. Mr. S. Ghosh, counsel for the review petitioner, and Mr. S. Banik, learned counsel for the respondent number.
Respondent number one.
Respondent number one. Respondent number one are present. What about two?
Two state of person. 2, 3, 4, 5 is the executive officer Karimganj. Number 6 is the chairman, Karimgঞ্জ.
Notice has to go. The notice has to go. Who was appearing for that, for this, town committee?
In the.
Yeah, just
in the
add there one more
revision,
thing.
town
Just
was,
just a moment.
municipal board was not the party.
Just a moment. The Mr. has been for opposite party number 1 and Mr. K. Bhattacharya, government advocate, appearing for respondent opposite party number 2, 3, and 4. Yeah. Mr. Bhattacharya, this executive officer Karimgঞ্জ Municipal Board, you appear for them also? No.
Yes, they can.
No, let him answer for that. Executive officer Karimgঞ্জ Municipal Board. Mr. Banik, you have a copy, show it to him. No.
Municipal board is not.
Executive officer becomes a government official. Now, whether you will appear for them or no. But just tell me one thing. If there is a chairman, can there be an executive officer also in a municipal board?
No, it is
Yeah.
not chairman, development authority. It's separate entity.
It's a separate entity.
Yeah.
So Karimgঞ্জ Development Authority also he can appear.
Yes, authority can also appear as well as the executive officer. Because.
You just take instructions, come back after some time. Ask somebody in your office whether you can appear for 5 and 6 or not. We'll take it up after some time. In some time, you just get instructions. Okay. Okay. Just get instructions. You can appear for 5 and 6. No, that I don't know. I'm asking you. If you say yes, it is okay. If you say no, we'll issue notice. Correct. After some time, let him get instructions.
Board is not the party. Board is not the party.
No, I don't know. I'm leaving it to him. I'm leaving it to him. Let him decide. Because if he's appearing, oh, okay. No, but it say GMDA. Is it? Development authorities are different. Okay, but take instructions. Will after some time. This item 35 and 36 will take it up after some time. Let him obtain instructions. Huh?
36 to could be like 35.
No, he's a government advocate. He's going out to make that call. So for that time, for that purpose, you are there in 36. Okay, then we'll take it up. Okay, just after some time, he'll come in 5 minutes. We'll just wait for some time. 37. Yes.
I'll be appearing for all the respondents in this case.
Okay.
I need some time to file the wakalat.
Okay. Mr. D. Mohanto, counsel for the petitioner, is present. Mr. H. Buragoy, learned counsel, appears for respondent number 1 and 4, and pays for some time to file his wakalatama. And affidavit in opposition, if any. Best after?
After a week.
You will be able to file your affidavit by then?
See, in the anytime in December, 15th of December.
Okay, 15 Make it 13/12/2023. Yes, Mr. Hussain. Okay.
We have filed that,
Huh.
he has filed this CRP, which is not maintainable because there are more than 7 acres of land. And I have parcels with performer respondents are not net filed in this case. Whereas they were the party in the title sheet. And they sold the land to performer respondents.
So oral sale, right?
Yes.
Without registration.
Her number is there. And that oral sale, that the thing is.
No, just give me 2 minutes.
That is the fixed formal.
Just a moment, just a moment.
Hearing. Permission. We have filed that in the lordship. That is in opposite.
Yeah, we will take my.
You are defendant.
I will do
You filed order 7 to 11 application. So what is the ground of order 7 to 11?
I'm not going to the merit for some primary allowed for hearing. Technical hearing.
Okay.
Very fine, I have not also.
Okay.
Figure.
Mr. Hussain, B. Hussain, counsel for the petitioner is present and pays for some time to address the court. Mr. R.C. Sekiel, counsel enters appearance for the sole respondent and submits that affidavit in opposition has been filed. You filed your affidavit?
Yeah, I filed.
So same is not on record, so the registry shall take this said affidavit on record. When do you want, Mr. Hussain? When do you want?
After a week. After a week.
Okay, list after a week. Okay.
39.
Taken, and no editor has been returned back. So the registry be directed to take the ID with the postal ID with us.
Okay. Mr. S. Sahu, counsel for the petitioner is present. Let the matter be listed before the Laozima court for passing appropriate orders as regards service of notice on the sole respondent. And thereafter the matter be listed before the court.
Postal ID taking.
Oh, they will do it.
40.
40. You want to do it, Mr. Sahu, you want to track postal service. You want to track it. Okay, Mr. Sahu, the counsel for the petitioner pays to allow him to track postal service. First of all, accordingly, the registry shall provide the postal receipt number to the learned counsel for the petitioner to enable him to track service and to submit postal track report before the registry. That will remain with the housing code policies. Okay. Yes, item 40.
IA minor.
Yes.
For verification, the judgment that is not is passed. Para 10. Page 20.
Yes.
Para 10 I am reading. Apparently it appears that the application under order 9 to 13 read in section 1.
not be approved, we need to demonstrate the appellate order passed in exercise of jurisdiction under order 43 rule 1 or 56. Even if the order was expired. Therefore, the court is inclined to allow the prayer made by the land in contempt of the petition and this present revision petition stands closed on the third liberty to issue a report of civilians number 1 such as detailed in appropriate petition. Give the petition and will subsequently can proceed with the original defendant. Number 1 is agreed by the order is mentioned. Past in proceedings of defense appeal number 12. So this liberty is to come before this one, not before the same. Just this much back. We'll have to file a revision under 115.
The present revision can close with liberty to the petitioner to approach the court of learned.
Revision. But I'm just giving a background.
Order 43 rule 1R.
Happened, man. Injunction violation epic was filed.
Yes. Is it good?
I am for the dependent man.
You're saying that this liberty was intended for this court?
Yes. Because I have to, because what happened, my lord, there was an application for violation of injunction. I am for the defendant. There was a status quo order in the form of injunction. Now, first court, trial court dismissed their appeal. Then actually appeal lies. And appeal was preferred by the plaintiff. That appeal was decided but expired. Now, then it was allowed. Against that, instead of coming to the High Court under 115, we filed an application under Order 41 Rule 20, Order 9 Rule 30. Order 9 30 will not apply because it's not a decrement. So that is why your Lordship said you can challenge the original order, but you have to come to this one under 115.
Okay, I now get it. Okay. Heard Mr. D. Mazumdar, learned senior counsel, assisted by Mr. G.R. Datta, counsel for the applicant. This interlocutory application has been filed for review and or clarification of the order dated 25/9/2023, passed in CRP 150 of 2023, which was 2023, full stop. Next para. The learned senior counsel for the petitioner has submitted that this court, having recorded the submission of the recorded his submission to the effect that application under order 11 rule 13 CPC was 9 rule 13 CPC was without jurisdiction. And consequently the order dated 24/7/2023, which was impugned in CRP 150 of 2023, was also without jurisdiction. This court granted liberty to the applicant to withdraw the said CRP number 150 of 2023 with liberty to approach the court again. However, while prayer made by the learned counsel for the applicant is recorded in para 9 of the order, in para 10 of the order, while granting liberty, this court granted liberty to the petitioner to approach the court of learned civil judge number 1, Kachar Silchar. Stop. Accordingly, it appears that the liberty granted to the petitioner, to the applicant to approach the Court of Civil Judge number 1, Kachar, Silchar, is an inadvertent typographical error which is crept in the order dated 25/9/2023, passed in CRP IO, say CRP 150 of 2023, not IO. Accordingly, the following words contained in paragraph 10 of the said order, which earlier read as follows, which read as follows, para 10, page 20. From starting from therefore, comma, that will start there. Just quote para 10 completely, para 10. So the said paragraph shall now be read as follows. Let's see this. This we will now be this, this quote.
This quote only.
And then under the next line will be struck off. Next is underline, complete underline will strike off. Only that much. So the second line, the entire line will be struck off.
This quote.
This quote only.
Yes.
It will end there.
Fine.
This quote in an appropriate jurisdiction. Correct?
Yes.
Okay. Next para. This order shall now be read together with the order dated 25/9/2023, passed in CRP 150 of 2023. Okay. Despite so much of effort, still these mistakes crop up.
It is all of us.
Huh?
Yeah, it's all of us.
Yes, Mr. Bhattacharya.
I solved the problem. I mean, the problem is that the notice has been sent to the address of the municipal report, and
Okay.
they will get to know who that exactly executive officer has been appointed by, and they will decide. That
Okay,
means
so
many
notice.
parties can appoint executive, including the municipal itself. So it's
I don't
very
know.
complicated.
I don't know.
Let the notice go to the proper address of that municipality. They will be getting.
Okay.
Municipality is not the party.
No, not necessarily the development authority. That's why we whatever, but we issue notice since he's reluctant to appear. We will permit you to serve notice by email to the. You can serve by email or Dasti. Okay. Here the order will be heard Mr. S. Ghosh, counsel for the petitioner. Also heard Mr. S. Banik, learned counsel for the opposite party number 1, and Mr. K.K. Bhattacharya, learned government advocate, appearing for opposite party number 2 and 3.
3 and 4.
2, 3, and 4. Okay, 2, 3, and 4. Yes. Issue notice. Returnable in how much time?
By within 15 days.
Okay, returnable in 3 weeks. The applicant shall take steps within 2 days for service of notice on respondent number 5 and 6 by registered post with AD as well as by way of Dasti by routing the process through the registry of the court, and upon service, an affidavit of service shall be filed prior to the next date of listing. So it is clarified that service of notice on the office of respondent number 5 and 6 would constitute good service. No, that is not praying. No. What the authorities will do is their call. We can't deprive you of an opportunity of coming to court again, seeking a restraint order on them. I'll be depriving you. Mr. Banik will be affected. I don't know. But I'll have to think for Mr. Banik first. Also, Mr. Ghosh. Not you are not standalone, Mr. Banik, but Mr. Ghosh also. It's okay, but you see, what the court can do is that we can only satisfy ourselves that the question asked is responded to, and it says that he is the sole owner.
No, he is not his sole owner.
No. You see, the order reflects that I made a specific query and specific reply was given. So after that, if that is erroneous.
That part, apart from that part, second part is very important.
What is the second part?
Second part, executive officer, direction was given to the executive officer, who is not the authority.
His name was struck off with it.
It's okay.
His name was struck off. For him to come in pleading review, in the legal bar. So far as.
No, that is on merit. I am not in merit right now. Right now, I'm trying to understand what has happened.
Whenever the practice taken up, with or without the affidavit, even if he's inducted, then we'll take an excuse. He's by the review of it, he's inducted. The writ petition, it has been the final. And so far as the other legal areas have been heard, he would not have submitted otherwise.
Mr. Banik, please try to understand. I am one of those persons. When I have an urge of having an water, I start digging the well then. You get it? Because if it is not relevant, if I can dispose it off, but today with your hearing, there are the statement made by you doesn't get registered here. Because if I can dispose it off, then I can understand and appreciate your argument and have a retentive value of that argument. So right now it is not just registering. At least after 3 weeks. So just objection, if any, be filed by then. After 3 weeks, give a date. After 3 weeks.
That's because I have served justice on this date.
Okay, give a date after 3 weeks.
24/1.
24, no, 3 weeks from today. Oh, month ago. Well, then give it before that, in the first week of January. First week of January. First week. No. Because second week is more dangerous. It is clear, close to you. No. For us, it is very difficult.
December 2020.
Huh?
Yes, 2012.
No, leave it. 36. Yes.
You retired common servant, you retired as a UDA man, and you were given the benefit of retrospective of promotion minor. You applied from 1/10/2015. He paid for 1/10/2005. That was not allowed. And your lordship, the judgment minor. Case number 101 minor, where the lordship has come to a finding that there was no vacancy because it will settle to the last page.
Which page?
101.
101.
Last 4 lines.
Yes.
Moreover, moreover, it will settle the position on normal circumstances in the event of non-availability of vacancy. Question of unpaid denial of promotion cannot be. Therefore, even the petitioner is placed in the rank of reviewing the assistant in the civil and responsibility, therefore it is found that the responsibility is correct. If there was no vacancy in the promotional post, entire exercise would be exercise of futility. And other circumstances, but actually, fact is there was vacancy. That's what I'm going to say. Because we have made an IT application and they have found that there were 47 section posts. That next page you'll also find. There is a section post given by the additional deputy commissioner during that period. And out of 47 section posts, from 2005, I've given the seniority list. From the seniority list, it appears there are 2 vacancies are always there. Since 2000, since 2015 to 2006 to 7, up to 2017, 16, 17. So there was no that is not actually correct. That is our. My prayer was not allowed only on the ground there was no vacancy. And that was the contention of the respondent that during the event from one phase, I paid for one phase 2005. From one phase 2005 to 39 2015, there was no vacancy according to the respondent. The order list they have submitted, but they are
No, but if this is a incorrect finding of fact, then you have to go in appeal. I can't.
Actually, they have not submitted any document.
No, may not be. Come to page 100. In page 100, that is a stand for third or fourth line.
Yes.
Therefore, the petitioner has been promoted to 2 ranks, so and so, so and so. Therefore, the court is of the considered opinion that in view of the consistent stand of the respondent, that there was no vacancy in the post of senior assistant. There is no scope of antedating the effective date of promotion of the petitioner. So, therefore, it's a finding of fact. If the finding of fact is wrong,
the finding of fact was there based on the fact that actually they have already submitted. That was not there in writing by the documented proof was there. But I like that just by one pointed out there was census stand was 47 and only from 2005 2006 it was there were altogether 44 vacancies were there. 44 4 vacancies were there. Similar all around there were vacancies that I have said in my this greatest list here.
no, that stand is there.
There is the affidavit. I given the affidavit also.
No, just give me 2 minutes. Let me recollect.
They have categorically made any statement with the effect. I will put the copy of the affidavit.
Yeah, just a moment.
On deputy commissioner has filed an affidavit, you also find that page 72. He talks about the Tamil Nadu. Vidya has given
It is okay if you are going on that.
No, there is on record. Yes. Come to your come to the writ petition at page 37. It'll take me some time to recollect, but I'll recollect it. Page 37. Paragraph 6. Learned counsel for the state, however, submits that promotion cannot be given unless there is a vacancy available. It has been submitted, the petition seems to have been given promotion on the basis of so and so, and submit that if vacancies are available earlier, the government can consider the case for promotion. So therefore, stand of the respondent in the earlier round of writ petition, which is what you call WBC 194 of 2017. So that is the stand, that there is no vacancy available. That is Justice Honorable Justice Koteshwar Singh.
Yeah, they have taken the stand. Yeah, but here in the affidavit, they have not.
No, I don't know that, because you see, irrespective of your submissions, I have gone through the record, and it is only incidentally that since I had gone through the record, I can pinpoint.
Because I have both the affidavit filed by the.
No, that is okay.
But
But this is a consistent stand taken by the government earlier that there was no vacancy, and that part of the and this part of the record that the vacancies were available could not be dispelled at that point of time. Now, how do you say that there is a vacancy?
Because first of all, on the basis of the reply to RT application, they have said that the total strength is 47. That you will also find page 103. I was senior. 47.
The point was that whether we were not promoted to the one of the senior assistant, then how can he be promoted to senior?
But he says now that the vacancies were available and the government did not change that, did not put that stand on affidavit. But there is a stray observation in an earlier order of this court, where the stand of the government is that there was no vacancy. No, but if he has a document to show that there was vacancy available. No, even in that case, review would not be an appropriate jurisdiction to correct the error. It would only be the observations made in the order is merely an observation. We are recording your statement, so it may be right, it may be incorrect. I don't know. I'm not making any comment on that. But the question is that if I have relied on something which is there on record, but it is erroneous, then I think it would be the appellate jurisdiction which can correct it. In review, I cannot change the order only on that.
My lord, may I submit, my lord? So whatever they are saying is RTI was placed before this court after my lord took the decision, passed the judgment. Then whatever, this was not in record on the original set of paper, which my lord decided on. So now this has come after the judgment. So let it go to the appellate court. They will be able to file affidavits.
That's what we are just thinking aloud.
Every case, everybody will be coming to reopen.
No, I'm not concerned with everybody. Let them come. Why should I stop them from coming? But the question is whether in this case it would be appropriate or not. That is the decision to be taken.
But then in every case, after the case is closed, somebody may get something.
No. I told you, Mr. Bhattacharya, I'm not concerned with everybody. And if I start considering everybody, then I would not be able to do anything. I would care for a ripple effect of the order. I'm not concerned what happens after the order is passed. I can't keep on tracking ripple effect of my order. You understand ripple effect?
What I'm saying is I agree with what my lord has pointed out.
It's okay.
So not on record on that date when my lord passed that. Just come after that.
I don't know. Just a moment. Mr. Korke, I'll close it with that observation. If deemed appropriate, you can file an appeal. I think if I'm factually incorrect,
Actually, those documents were not before the report matter, which I am enclosed matter.
no, it's okay, but even that erroneous decision would not be a ground to correct it in the review jurisdiction.
Proposal basically is that government has already submitted, basically, that there was no basis at start.
It's okay, but it goes to the root.
Yeah.
If it's an incorrect finding, then it goes to the root. Review may not be an
Affidavit
appropriate
also
decision.
filed by Mexico. They have not categorically stated that.
No, it's not stated.
So there is no, on pleadings, there is no link that there was
Okay.
no vacancy on. They already submitted.
It's okay, I'll record that statement and close it. Heard Mr. P. Kotogi, counsel for the review petitioner, also heard Mr. J. Hendick, learned standing counsel for respondent number 1, and Mr. K. K. Bhattacharya, learned government advocate appearing for respondent number 3. No, then 2, right, Mr. A. Chalia, standing counsel for finance department, respondent number 2, and Mr. K. K. Bhattacharya, government advocate appearing for respondent number 3. Next, fella. This application for review is directed against the judgment and order dated 22/8/2023, passed by this court in WPC 1964 of 2022. Next paragraph. The learned counsel for the petitioner has submitted that one of the considerations based on which this court had dismissed the writ petition was that this court had accepted the stand of the government advocate that there was no vacancy in the promotional post. In this regard, the learned counsel for the petitioner has referred to the affidavit in opposition filed by respondent number 3 to project that the respondent number 3 had never taken a stand that there was no vacancy in the post of senior assistant. So hence it is submitted that the finding of this court that the entire exercise would be an exercise in futility was based on incorrect premise. So accordingly, it is submitted that this was a fit and proper case for exercising review jurisdiction and to revisit the impugn order. The order impugned this review petition. Last people gone like this. No, yes, sir. Next para the respective the learned departmental counsel as well as the learned government advocate have made their submissions. Next para. The court finds that the reasons are assigned in the order impugned in this review petition for not for rejecting the prayer made in the writ petition. Stop. Insofar as the stand of the respondent authorities that there was no vacancy available is also found to be contained in paragraph 6 of the order dated 11/12/2018 passed by this court in WBC 194 of 2017. Stop. Next para, under such circumstances, comma, if any error is crept in the order why it cannot be said that that there was an inadvertent error that has crept in the impugn order. And therefore, the nature of error which is urged by the learned counsel for the petitioner can only be rectified by way of asserting the taking appropriate steps against the impugned judgment and order impugned in this review petition. So therefore, therefore, the matter is therefore the petitioner will take an appropriate call in connection with the order impugned this review petition as he may be so advised. First off, as the court has arrived at a finding that it was not a inadvertent typographical error which is kept in the order, this review petition stands closed. It's liberty to the petitioner to take such appropriate measure as he may be so advised.
41.
Just a minute. It will answer. Yes, 41.
First step, there is a delay of 263 days.
263 days. MSCT appeal. Yes, C. Mazumdar. Counsel for the applicant, the condemnation of notice. Take steps within 2 days. 42.
Delay 1138 days. There is a delay in
How much delay?
1138 days.
11:30. So why should not dismiss at the motion stage?
Claim petition was dismissed for non-prosecution.
Yes.
Learned English Council taken step on 2 days, but despite of several, in page 4, para 3, I have stated one.
Page 4, para 3.
The learned may reflect.
No, you see, you are blaming the lawyer for not taking steps. You have never once said that you were pursuing the matter and the advocate was not taking steps. So if there is a 1100-day delay, why should we entertain your application and why it should not be dismissed at the motion stage?
Applicant has no knowledge regarding this. Page 57 is
No, you see, you are Mr. Hussain. Mr. Hussain, you should make a statement, number one, that you had given instructions, you had given cost for the taking of steps. Because although we know what is happening in MSCT, but still the fact remains that under the Bar Council rules, the advocate is required to move only when the cost and other things are provided to him. So it is not your statement that you have given him the requisites and steps were not taken. Because then you will have to make the lawyer also a party here. He will be doing a misconduct. So you are, it's not your case that the advocate did not act in accordance with your his mandate. Because I don't know of any circumstances which binds a lawyer to take steps when he's not paid. In the absence of steps, I am not issuing a notice, I'll be dismissing it.
The youngest council on your two occasions inspection taken. And the insurance company has appeared and submitted written statement. But later on, upon the respondent number 1 and 2.
No, I understand, but I'm telling you the proposition of law. Under the Bar Council rules, the duty of a lawyer is to the extent he's instructed. If the lawyer is not instructed to take steps, why will a lawyer spend from his pocket and take steps? It is not your stand that on so-and-so date I gave him money.
Paid money and he was instructed, but he was.
There's no statement to that effect. In absence of this step, you'll have to tell us the name of the lawyer whom we have given money. That has to be an oath, because mechanically I'm not issuing a notice even in condemnation application.
And then he filed a complaint before the Bar Council against them.
No, you do whatever. I'm not suggesting you what to do. I'm saying that here in this application, you have not made any statement. What you do, what sort of complaint you make, it's your own call. But in the absence of any statement here, I'll be dismissing this application.
So later on, the application was also filed. I ordered 9 rule, 9 bucks. That was not considered.
Pardon me, I did not get you.
Page 58. In
Page
58 in memo.
58. So Hussain, we'll have to dismiss your application on two grounds. Number one, the explanation given is not acceptable. And number two, you are claiming that there is a delay of 1158 days, right? 1158 days. I find that your case is, there is a delay of more than almost 1600 days.
COVID period. COVID period exempt.
COVID period not get exemption. That falls within the period of limitation. 2018. 2018 limitation is 90 days to file an appeal. So the COVID came much after 2018.
Was calculated in the name of regulation. By the filing section, that limitation was calculated.
No. You see, when you are presenting an application, you must do your own exercise. Office is, there's no presumption that the office is always right. Your application was dismissed when? 21/6.
2018.
2018. So you see, limitation is not counted from the date when application under Order 9 Rule 9 is rejected. Your application to delay will refer back to 2018. 2018 to 23 is 5 years. 365 into 5 is 5 is 25. 15 or 16, 25 days. So 1600 days delay, I'm just counting. 1825 days, sorry. 1825 days. So your explanation of 1158 days it itself false.
Up to 15 March 2022, COVID period is calculated from the limitation.
No. You see, if the limitation, you take account on Limitation Act, you have a count. If the period of limitation expires before that, you don't get that benefit. If your appeal period was within that COVID period, then I would have understood. Suo motu 3 of 2000. But if your limitation expired earlier, you'll have to show each and every day delay. Even COVID, you'll have to show an explanation. You don't get automatic exemption from the period of limitation.
But if any other day, I will satisfy it.
Oh, I'll not be satisfied because you see, I've told you the law. Question of
For the fault of the lawyer, the petitioner should not be suffered. Sometimes the judgment.
no. You see, you have not alleged the lawyer was at fault. The fact being that in your application, you have given a statement that it is because of misunderstanding you failed the date. Look at your petition.
That is correct.
So if it is misunderstanding, question of lawyer being at fault is only a default.
That was a 21/6/2018. When the matter was first dismissed for default, they have communicated to the appellant and to the appellant has appeared and filed a petition under Order 9 lawsuit for restoration.
Yes, I can understand that. In that petition, what is the first line? You say that there is a misunderstanding in getting the dates. Once it is a case of misunderstanding, it's an accepted position, you know the law then. Advocate did not take steps, that is okay. But it is misunderstanding. Misunderstanding, you will have to show something more. You see, because out of fear that somebody may sue me, I was once in your place. So people may sue me for not taking steps. Some matter might have been dismissed for default. I have maintained all my diary. The date was diary which I have been maintaining as a lawyer. I still have that. Just out of fear that somebody may sue me, that I defaulted in taking steps. So even at this stage when I am here, I'm still afraid of any inadvertent default I might have committed. And I'm maintaining those diaries. So question of misunderstanding when it is there, you are taking the responsibility on yourself. The onus shifts from the lawyer. Misunderstanding means what? That you were informed of the date, and misunderstanding means maybe June you read as July.
Correct.
But then why not July, August, September, October? Why after 5 years?
Being a beneficial law lordship. Maybe.
No fault of the lawyer, please attribute it to a lawyer. You have not done so. You could have, you could have at least told us in the petition that you have given appropriate instructions to your lawyer. You merely say somewhere you have written that you were, what is it word? You were, it is a particular word that you were.
Petition was filed only on one page, lordship, and that petition.
No.
was two-page, lordship. Yes.
Don't tell me that. Don't tell me that. Have you read CPC? Have you read the form of plaint in a CPC? It is not more than 1 page. I'll show you that. Don't tell us about the form. Form is something, if you, yes, it can be 1 line also. Even in 1 line, you can draft a plaint. Don't tell us those things. You read the form of plaint. Have you ever read the form of plaint? As a lawyer, have you read? Tell me honestly, you have read it. See, in a money suit, how much paragraphs are there in the form? Can you tell us? You can't tell because you have not read. It won't exceed 8 paragraphs, including the cost title and the prayer. I'll show you. Here, given the CPC, correct.
Here only one, and how can I say lordship develop?
I'm showing you something. Go through it. You see, Appendix A of the plaint. It is in the backside. Appendix A. See form number 1, plaint for money lent. It is 6 paragraphs. And 6 includes prayer. You found out. Appendix A, form number 1, plaint, money lent, 6 paragraph. Money overpaid, 4 paragraphs. So don't tell us 4 paragraph plaint, 1 page plaint, 1 page petition.
One line.
No, even 1 line is sufficient. If a lawyer knows the art of writing 1 line, I can dictate to you. I can dictate to you. You want a statement in 1 paragraph. I can dictate it to you.
Lordship, that
No.
petition was filed before that court.
Not acceptable.
Lordship, any other day, lordship.
Just not acceptable.
Suffer, lordship.
You see, we get writ petitions of dismissal of workmen from service, which runs into about 10-15 pages on an average drafting. For a person who's dismissed from service, you'll find a plaint not less than 10 pages. Correct. Come to form number 15 of this Appendix A. 5 paragraphs. You seen that?
Beneficial rather or that lady.
Okay. In order to on a query of the court as to why on insufficient explanation of the delay, this application should not be dismissed at the initial stage. The learned counsel for the petitioners placed for and is granted time to address the court. Placed after a week. Okay.
October item 25.
This one 42. What is this 42 for? Huh?
42 to
Oh, अच्छा 42. Okay. नहीं नहीं ठीक है एक तो देखा ना
25.
Yes 25.
That is the issue. LCR is not. From
Yeah,
Oh, अच्छा I see. Huh? Just a moment. Just a moment. नहीं ठीक है सर मैं thought so.
Title should be the
না না বুঝিছো কিন্তু মানে কি আছে এই মোক থাকিব তাতে Mr. M. J. Barua, counsel for the appellant, and Mr. M. Barua, M. Gogoi, learned counsel for the respondent are present. Seen the communication dated 28/2/2023, issued by the learned Muslim number 1, Kapro Metro Guwahati, that they are searching for the records of TS 225 of 1998. Accordingly, matter is adjourned to enable the learned trial court to trace out the record and send it to the court. Next para. The LCR relating to PA 23 or 2002 has been perused. Well, the receipt of records of suit is recorded in the order dated 18/11/2003 in TA 23 or 2002. There is no order or office note regarding return of the LCR. So, next, according to the registry, have sent a photocopy of the order sheet of TA 23 or 2002 to the Court of Learned Monsif number 1, Kamru Metro Guwahati, so as to enable the said learned court to track the trial court records. The same may be sent by a special messenger. List after 4 weeks, awaiting receipt of LC of title suit records. You have a copy of this evidence and everything. You have copies of that trial court records. Specifically, we'll read the evidence part.
We will see if we can.
Try to see on the next date. You try to find out if you can reconstruct it. We'll take it with your consent. Because otherwise, we'll have to pass an order for reconstruction of record. That will be under the civil code rules and orders, and that has to go before the learned trial court to have a record reconstituted. But if you give a consent, we may take copies from you and then proceed with it. It will be simplification. Otherwise, reconstruction of record must be ordered within the meaning of the civil code rules and orders.
Anyway, it's a case of abatement.
No, I'm not on that. But since we are dealing with the second appeal, we are bound to look at the records. I'm making an offer to you, because if it is reconstruction, then it must the procedure prescribed must be followed. Correct. And if you both give consent, you can accept it and proceed with it with the hearing.
Yes,
Correct. So both of you decide together. Yes, Mr. Saiwala, your matter 46.
46.
Here,
Yes, come.
this matter will come up for admission also. Today at first.
Your first appearance. Yes, Mr. Saiwala. When? Agree to a date.
Next week. Next week.
So it's a date. We'll fix it on that day. Both of you.
Maybe on 5th, 6th.
6th of December. Okay. Mr. G. N. Savila, Senior Counsel, assisted by Mr. P. Decker, Counsel for the petitioner, as well as Mr. S. D. Purkar, sir, Counsel for the respondents. You are appearing for both. Respondents are present. So as the respondents have entered appearance to the learned counsel, list the matter in the admission column on 6/11/2020, 6/12/2023.
Published.
Any interim order is there?
It is still the further order.
And further order.
Okay.
Further order.
Okay.
48.
48 appeals was not probably appeals Rajesh didn't go to the
5/2. They are not in the address. They are not in the address. Here's the service report. But then you'll have to, you'll have to take newspaper publication of notice.
Yes.
One over, second line or third line.
Seems time will be granted, my lord, to ask.
Huh?
Seems time will be granted to ask.
Huh.
Or to take steps.
To take steps. To ascertain correct address or to take newspaper publication?
To ascertain.
To ascertain correct address. Okay. In view of the office note, sorry, process servers report, Mr. G. N. Savila, Senior Counsel, assisted by Mr. P. Decker, Counsel for the petitioner, placed for some time to ascertain the correct postal address of the respondents. So this after 3 weeks as paid for. Interim order passed today stands extended till the next date of the same. $49. Yes.
But by the last order, the officer has directed please send copy of the case report document to send by email. But as per order, office number 24/11/23, that has not.
That has not come. Okay.
As per the method, sending the report.
Yes, yes. Mr. J. Decker, Counsel for the petitioner. And Mr. N. Hawk, Counsel for the, you have for all the respondents, for the respondents are present. In view of office note dated 24/11/2023, the court shall issue a fresh reminder to the Court of Learned Civil Judge within bracket Junior Division, bracket close number 2, Kamrup Metro, Guwahati, to send number 1, it was a last order, 1, 2, 3. So scan copy of so-and-so, scan copy of 1, 2, and 3 by email for being placed before the court. Let a copy of this order be placed before the Court of Learned Civil Judge within bracket Junior Division, bracket close number 2, Kamrup Metro, Guwahati, by email.
Court has passed an order to the petitioner.
Huh?
After this order, court has passed an order. I think whether they have the expertise or not, that's the thing.
I have downloaded this order from the court website. Okay.
3011.
And so as to enable the learned, the said learned court to comply with its direction contained in the order dated, in its order dated 4/11/2023, passed in TS 39 of 2022. Interim order passed earlier stands extended till the next date of listing. This after 3 weeks. Huh? No, because you see, we are last again in that very what you call. No, I understand, but the timings are so bad. Again, it comes before vacation. Please make a mention if it is not listed. 50. Yeah, okay.
Lordship, we have no objection if the ex parte evidence has been completed and if they are allowed to means file their written statement before the principal judge.
Okay. Your Vakaratma, your file? It is. Your name?
Yes, Rava.
S.
Yes, Rava.
Heard me says Rava, counsel for the petitioner. Miss
D. Sharma.
B. Sharma, then the counsel.
D. Sharma.
D. Sharma, counsel for the respondent, has entered appearance and has and upon instructions has submitted that the respondent, who is the estranged wife of the petitioner, has no objection in allowing the prayer made in this revision filed under Article 227 of the Constitution of India, was to permit the respondent, the petitioner, to contest the matrimonial proceedings by filing a written statement. Sorry, his written statement. Next, she has also submitted that that she has filed her wakalatnama in connection with these proceedings, which was accepted under receipt number 7453 of 2023, dated 29/11/2023. Full stop. A copy of the filing memo is kept as a part of record. Next, para. As the respondent has considered to the prayer made in this application, this application against the order dated 18/9/2023, passed by the learned family court number 3, Kamrup Metro, Guwahati, in Miss J case number 45 of 2022, stands allowed. Without entering into the merit of the order, So resultantly, the said order dated 18/9/2023 passed in NIJ case number 45 of 2022 stands allowed. Full stop. However, the petitioner is directed to file his written statement within 11/12/2023.
I don't know, the next date is fixed on 12/12. For the
12/12. Okay, on 12/12/2023, the date fixed. So it is made clear that if written statement is not filed within the extended time of 12/12/2023, the opportunity to the petitioner to file written statement to contest the matrimonial proceedings would be lost without any further order of the court. Stop. Next, it is provided that in the event written statement of the petitioner is filed within 12/12/2023, the learned Family Court number 3, Kamrup Metro Guwahati, shall accept the same. And permit contested hearing in the proceedings. Full stop. With the said observations, this application stands closed. Since partly allowed as indicated above. Yes, now some cost to her. He has entered appearance and what you call permitted you to contest the case. She's a wife. Are you paying maintenance to her? No.
The petitioner is the father of the deceased son. The petitioner is the father of the deceased son. The maintenance case.
Oh, acha. I now remember.
He's a 78-year-old person.
Oh, now I remember. I remember the case now. Okay. We are not giving cost to you right now. You know the reasons why. I need not spell out. Okay.
Right.
Item 43, 44, 45 for hearing.
Hello, address on 43 and 45.
Yes. You have time today.
I will not.
Ah.
If my preference only evening day,
Yes. We can fix it tomorrow. How many cases are there tomorrow?
Can it be on the coming?
No, I just take a call because you see those a lot of matters are parted before this bench, so therefore I am facing some difficulty.
14th
14th.
with Jotas.
Okay. Then next Tuesday.
Yes.
Next Tuesday would be 5th. Okay. Mr. G. N. Savala, Senior Counsel, assisted by Mr. P. Rekha, Counsel for the petitioner, as well as Mr. K. P. Pathak, Standing Counsel for Forest Department. And Mr. Barba, you are for? We are present. With the paucity of time, the matter could not be taken up today. First of next para connected, the petition has already been heard and reserved for delivery of orders. So accordingly, there is this matter as a parted matter on 5/12/2023. Please make a prayer, we'll upgrade and take it up. Please remind me in the at 10:30 in the morning. So 10:30 we make a mention so that I may take up the matter. Otherwise, I tend to forget.